Yes. Yes. Parents to mention the matter is in your lawsuits board laws. Hearing item 37. It is not a normal usual hearing law. This is regarding release of property. I have filed a mistress for interim release. If your lawsuit can direct the matter to be listed in order set, it can be taken up and can be disposed of within 2 minutes. This is not the regular criminal appeal.
Hearing is item 76. Possibly not.
Let us see 100 some method.
That's it.
So cases are stayed before the file. The witness of execution case. Till late, the wife has not get a single file.
What is this matter?
Criminal inquiry.
Oh, year like 1986 now. 19.
Can you mention item 1 to 5?
No. Item number 1 permitted to withdraw.
Withdraw, yes.
Number 5 and pasture.
Yes.
Item 6 to 13, 14 to 22, 23 to 26.
Item 24. The lordship has fixed to taken up at 2 p.m. From our side, the written note is required to be prepared finally some other day in this week or next week.
You
I will intimate.
Intimate.
Already
intimated.
Yes, that association.
Right.
27 to 30, 31 to 35, 36 to 41, 42 to 46, 47 to 52, 53 to 55, 56 to 59, 60 to 65, 66 to 70, 71 to 73, 74, 75 to 83, 84 to 87, 88 to 92,
88 and 89, two analogous matters. They come for the first time after my appeal, time after for the appeal battle. I pray for some time to take instruction in the matter. My learned senior is here for the.
This is a covered matter. Let it come on 9th or 10th minutes. 10th.
10th.
There's an interim order to continue.
88. Interim to continue.
Both of us. 88 and 89.
Both the cases.
88.
93 to 99, 100 to 103.
Your lordship special weekly list, item number 1. It's a criminal matter. It may be disposed of, lordship. All the company and 5 partners were there, out of which company has been closed and 4 partner, all the partner expired except one lady. She is also an old lady who has been undergone for open heart surgery also. I am submitting all the report. There is another case attached with this, but it has not been tagged with that.
Same thing.
Same.
But tomorrow, this will supplement. The other matter, you give the other matter.
Item
396.
Item one is supplementary. Along with that, this another matter.
Yes.
Tomorrow.
It may be disposed of.
Tomorrow we will discuss. Supplementary. Okay.
Yes.
Item 2,
Here I have challenged the property tax order taken by the learned HDGF. On the ground that check was issued to the wife and daughter, but complaint was filed by the husband.
Let us see. Let us see. You are the
And accused.
accused. Sardhakar Sahu.
Para. Page 8, 3 facts.
Yes.
The complainant sold his doctor and the
Complaint received the payment
and he had given 2 checks in favor of his wife, then Marissa, and another who is Dr. Modi Smita Sahu.
Has he been authorized? to file.
Position is no authorized.
Have you moved application before the trial court? Why have you not moved? I will allow you to move application right now. By petitioner by way of the present petition seeking quashing of the order dated 28/9/2023 passed by letter DCGM Birbhum Bir Maharajpur in 1CC case number 9 of 2023, whereby cognizance of offence under 138 NIS has taken against the petitioner. The counsel for the petitioner drawing the attention of this court to the complaint petition at para 3 submits that in fact the checks in subjects were issued by the wife and the daughter.
Yes.
Wife and the wife of the petitioner. Gitanjali Sahu.
Wife.
Of the respondent, Gitanjali Sahu and daughter Madhusudha Sahu. He has drawn the attention of this court to para 3 of the complaint which is agenda. On the basis of the aforementioned submission, he submits that the trial court has not applied mind while taking cognizance of the offence, and he further submits that the complaint is not maintainable. Complaint against the petitioner is not maintainable. However, on query from the court, he submits that he has not moved any such application for the trial court. Therefore, the petitioner is granted liberty to move such application, move appropriate application for the trial court, drawing the attention of this court to the aforementioned facts. This order is particularly passed because in the present petition, the entire record of one single case number so and so is not available. Is not available. With this, the petition is disclosed. Yes. Okay. And it is expected that the trial courts will deal with the application and pass appropriate order. Yes.
Item 3.
Made President. This is for quashing of the proceeding initiated against the present petitioner in TR case number 24 of 2017 for the offences under section 13(1) CD, punishable under section 13(2) of the Prevention of Corruption Act and section 120B and 409 of the Indian Penal Code. The allegation against the petitioner is that
You are taking quashing of what? The 27/4/24 order is?
Order is a rejection of the application for discharge.
Okay. Yes.
And I have sought for quashing of the proceeding and setting aside the said order.
Yes.
Lordship, the actual aspect is that on 2/6/2012, the DSP Vigilance Jajpur unit submitted a written report on the basis of which this case was registered.
How many cases are there total?
Total, Lordship, the impugned order is annexed 5, Lordship.
6.
There are 6, Lordship. 6 out of 2 are private auction holders and 4 are officials.
Yes.
And I am the accused number 3,
Ravindra Kumar Tawar.
Ravindra Kumar Sabat. Lordship, the allegation is that a PIL was filed in this honorable court alleging illegal mining of some 2 Moram mines in the district of Jajpur. And this honorable court directed the RDC to submit a report and to inquire into the matter. The RDC directed the ADM to inquire into the matter and to submit the report. The ADM alleged that there are illegal mining, and the ADM further requested the government, submitted the report to the RDC to stop any auction of the mines till the matter is finalized. However, it is alleged that despite the recommendation of the ADM, the Tahsildar of Dharamshala recommended for auction of the mines, and the sub-collector, who is the competent authority under the rules, performed the auction. And in the auction, it is stated that the private auction holders, who are the accused persons number 5 and 6 in the case, they got the mines and they committed illegal mining.
Who are you?
Lordship, who are you? I am the Tahsildar, second Tahsildar. The allegation against me is that I recommended for auction of the mines.
Despite an order by
Despite the recommendation of the ADM, because the auction is to be performed in due time as per the rules, and the government had not stopped the auction. That was the recommendation of the ADM, and it was for the government to direct me not to conduct the auction. Not to me, but to the competent authority, that is the sub-collector. And what has happened, they have, what the vigilance has done.
Show me the sub-collector's first order.
The sub-collector is the competent authority under the rules.
No, the ADM's order, ADM's advisory.
ADM conducted the inquiry.
Where is that order? Let us see what is the
That order is not there in the case. It is not a part.
That is the genesis of the entire case.
A basis of the, my learned friend can say.
In this case, basis of the direction issued by this honorable court, vigilance took up the investigation and submitted a report. And your lordship can.
Where is that report? What is the tone and tenure of that report is necessary to see.
On the basis of the direction of this honorable court to conduct an inquiry and proceed in accordance with law, the vigilance conducted an inquiry, found the illegalities and registered the FIR. Investigation has taken up, and the during course of investigation that has been mentioned, what has been found by the ADM,
Yes.
even the charge sheet that has been categorically mentioned, there were illegal mining and restrained that mining to not to give further lease. And despite that,
That's what I am asking. Where is the ADM's order? Show me tone and tenure of that order. That is the genesis of the entire case.
your lordship can see that has been mentioned in the charge sheet also itself.
Where is the order? Can you give me that order? Let us see.
Let them provide the order.
Get that order. That is the genesis.
Lordship.
What it says,
Lordship.
whether it is a complete ban, whether it was duly communicated,
Lordship wants to go to the genesis.
that is the real
That
thing.
is the genesis.
Thing is that apart from it, with all respect, I will submit that order, order of the idea inquiry. Apart from that, knowing fully well that there was illegal mining is going on, and those petitioners.
No, what he's trying to say is every year timeline is there for the purpose
Yes.
of auction.
Yes.
If there is an investigation or there is a report, ADM has said that don't proceed or something of that sort. Despite that, if he has proceeded, because he has to stick to the timeline. As per the timeline, he has proceeded. That's what his case is.
Yes, it's not apart from the fact that despite the restraint order of the ADM, the petitioner.
Where is that restraint order?
Apart from that restraint order, they have allowed illegal mining beyond the leasehold area.
That is another.
And allowed the leaseholders to
No, what is the allegation is
twofold.
tendering,
Twofold.
only tender.
Not tender.
Then
That is illegal mining and misappropriation of by way of illegal mining, they allowed the leaseholders to extract the mining beyond the leasehold area, and by
that is the second allegation.
that is the main allegation. Basing upon that allegation, they
You got that ADM's order. ADM's order.
I'll
Shall I put it on next on
After 30th, Lordship, I am not available till 30th.
30th of
September. No, it is August.
Okay, August. Then you keep it on
First week of September.
somewhere in on 9th of September.
9th of September.
9th
All
September. Think- Get that order. Let us see.
So I think there is an interim order to file an application. Whatever. Interim order to continue.
Item 4.
Four. Not yet been admitted, my lord. POXO is there. Interim bill have filed, but getting the appeal may be admitted.
Today for instruction.
Sorry?
Today for instruction interim bill.
The delay not condoned, not yet admitted,
Not admitted.
not.
No,
Last
he has
time I
moved an interim application for that call for a report. Perfect to the order dated 12/8/2023. The state council has not obtained the instruction verifying the medical document of the applicant. Therefore, the interim bill application is adjourned to 22. Meantime, the state council is to obtain the instruction regarding the health condition of the applicant. The appeal has not yet been admitted. Is there any delay?
388 is.
12 days delay, my lord, for
No.
official.
We have 12 days to file in the jail criminal appeal.
That may be condoned.
Chance condo, appeal admitted, all for the right of record and so. This matter after on 30th. 36. Okay.
My lord,
I have admitted. I will call for that report. You get that report. Yeah.
That the IA copy or entry application may be solved. So
Give
that
the interim application.
my lord, I will solve, my lord. This is the received, my lord.
Once again,
This is the received.
share a copy, 2-page application. Why can't you give another copy?
My judge,
Yes. Next, 5. 6.
I admit. Password. Right, please, Ross.
Hello, there is a my lord. Delay the 1-2 days, my lord.
Sorry?
132 days.
Delay.
My lord.
6 POXO Act.
Delay of 132 days report by the stamp report or stamps condo. Is there an application?
132 days, my lord.
Is there an application?
Other application they are
Stated in the application.
Yes.
I number 187 of
IA 187.
admit call for the record and it's gonna be offensive also issue notice to IO. Yes. Item 7.
A notice to informant.
That may be fixed, my lord.
Yes, next. Item 7.
7 also one of the offense rating to POXO.
Admit.
Notice.
Notice. Yes. Item 8.
8 also.
Same.
POXO in 3 years.
Call for the record. Yes. Item 9. Yes.
Complainant is before your lordship.
Hmm?
Complainant is before your lordship in appeal, wherein
Against acquittal.
against acquittal under 138.
Issue notice to opposite party. Process to file.
Great password.
Item 10.
Convicted.
It's also POXO is there. 9. 20 years.
Only file.
POXO is not there.
10 item 10. 10 years, sir. 376.
376 A.
372.
376.
10 years, sir.
Admit.
And,
Yes.
Stay relation of 5.
Stay related.
এটা মিলাইবেন।
The convictions are under section 376, 376, 376, 2N, 344, 323 of IPC to undergo RI for a period of 10 years.
10 years. What do you want?
Admission, kindly admit this for the.
Admit. Notice. Yes. Yes.
I think 12. Yes. Convicted for the period of 2 years. Under section 324 is concerned. He is in custody, my lord. Earlier, during trial, he was on bail. And now he is custody, my lord.
You're convicted
24/6.
Convicted and for which offense?
324, my lord.
324. 324. 1 year, 2 years sentence.
2 years.
And your custody since?
Custody since, my lord, 24/6/26.
24?
6/26. 2 months he is in custody.
No, but
Earlier he was on bail.
the judgment was pronounced on 29th November 25.
Yes, my lord. Before that, he was taken into custody. Since he was 1 day default, he was in
Custody
Belgium.
Since
24/6/2026.
24.
Again.
But they see during the trial,
He was on bail. He was
22/21 no, he was
6 दिन he was taken into custody. He was granted bail by the trial court.
you were taken to custody on 20th of February
Yes, ma'am.
and granted bail on 1st of
March. 6 days.
6 days.
How come you were taken into custody on 24/6/24? The judgment was pronounced.
26.
Huh.
1 day default NBW has been issued, my lord. Thereafter, he was on the strength of NBW. He was taken into custody. Trial.
Been convicted. Complaint has been convicted. Going to go right for so. Mr. Southland counsel for the appellant submits that 24 or 26.
24/6/26.
Submit
24/6/2026.
default for the appellant to appear for the trial court. NBW was issued against the bill, and pursuant to the execution of the NBW, he was taken into custody on 24/6/2024.
No, 6, my lord.
24
6/26.
20
24/6/2026.
26 अच्छा 26/2026. Okay, judgment, when the judgment was pronounced, you were not there.
And the custody.
In the month of November.
How can it be possible? 29th November 2025 is the judgment. Then
25.
November 25 is there.
Judgment, my lord.
Okay.
Thereafter, he was not moved for criminal appeal. Thereafter, NBW has been issued.
You say that.
Yes.
You say that. Right on. For different level. The petition is convicted. Although the judgment of conviction and order of sentence was passed on 29 November 2025, but the appellant was not taken into custody. Pursuant to the said judgment, NBW was issued against the appellant. On execution of the NBW, he was taken into custody on 24/6/2026. 24/26. He is in custody since then. The trial court judgment further reveals that during the trial, the appellant was taken into custody on 22/2021 and was granted bail on 1/3/2021. कितने मसाला है?
3 months, 2 months, 6 days.
Therefore, in total, the appellant has already gone 2 months, 6
Days.
6 days custody out of 2
years.
2 years out of 2 years. Mr. Sahu further submits that on merits also, there is a fair chance for the appeal will succeed. However, there is no chance of the appeal being heard in the near future, hence it's Hence he prays for suspension of sentence pending appeal regarding it to the period of sentence period of custody, nature of evidence, and if there is no scope of the appeal being heard in the near future, granted. Yes. Yes.
Obliged.
Next.
13.
Yes.
To arrive for 5 years and to fine 10,000. Convict under section 325 of 5.
325. 324. 324.
25.
25. Okay. 20. Okay.
And
5 years, na?
5 years. He is in custody since 3/6 2018.
3/6.
2018 to 14/3 2019. Thereafter, he was released.
Like total period, you tell me. I will
Yes,
not-
my test 27 years.
Tell me total period.
3/6 2018 to 35.
That I can read it. Calculate and tell me. You want me to evaluate everything?
1 year, 4 months.
1 year, 4 months total.
Yes.
Out of 5 years.
Out of 5 years.
And what are the antecedents? Antecedents. The trial court record reveals the appellant was taken into custody on 3/6/2018 and was enlarged on bail on 14/3/2019, and thereafter on again taken into custody on 3/5/24 and granted bail on 9/7/2026. Thereafter, when the after the judgment announced by the trial court on 9/7/2026, he still continued in custody. Therefore, out of the total sentence of 5 years awarded against the appellant, the appellant has already undergone 1 year,
4 months.
1 year, 4 months. Actual sentence. 1 year, 4 months, actual sentence. Since the appellant has been convicted for the offence under section 325 IPC, his antecedents is required to be certified from the state council, from the concerned police station, from the council. The state council is opening the antecedents and conduct of the appellate court. The state category, please the better on 18th. Get the antecedents. Okay, 18th. Yes, next.
Item 14. 14 not assigned to your lordship. It is SC/ST bail matter. That may be code number 3.
Okay. Yes.
Tomorrow it for that.
Not the release of this bench. Let it be listened for about 5 Yes.
Tomorrow manner. 15.
13, my lord, 13, the your lordship granted bail. Signed by 13.
No, antecedent I am asking 18. Yes. Yes.
Item 15.
15.
Appellants have been convicted under section 304B and sentenced to undergo
7 years.
7 of in time. They hold typically the appellant number 1 has given birth to in the jail. I have given the documents.
No, sorry, appellant number 1, what happened?
Appellant number 1 is blessed with 2 baby sons inside the jail.
This is a lady.
Yes, I have filed the documents.
Okay. Appellants are convicted for section 2 also. Which IA number?
902.
Yeah?
1902.
1903. Where is it?
02 is bell, 03 is stay.
Where is the
Annexure I have.
Annexure.
Annexure 1 in the high.
Let counsel for the petitioner submits that when the appellant number 2. Appellant number 2 while in his custody is delivered when she was pregnant and delivered baby boy or
Rita Behra.
Huh?
Rita Behra.
Twin,
This is the
twin.
sister.
twin children. And to that effect, twin baby. Yeah? To that effect, the relevant documents are also annexed. Let the State Council verify the same and file a report by 2nd of September. 2nd September. Verify and tell me. I'll have to release it. Yes.
16.
It is also, have been convicted under section 304B, and the husband has been.
Yes. For 16, what happened?
15 is also
15, 16,
304B,
Yes.
but the husband has, applicant number 1 has been convicted for 10 years.
I leave.
Others to 7 years.
Simply admit call for record. Yes, next.
17. There is the 109307 case, 7 years conviction.
30?
307.
Okay. Jail criminal appeal admitted. Admitted. Call for the trial court record. Call for a quantity. Right? Release the matter after the yes. Yes.
18.
Yes.
10 years. 76 one.
Same. Call for the quantity. And call for the record. Yes. Yes.
19. 19 Miller. There is a FOXO is there and 54 they delay the fire.
This for delay in filing the jail criminal appeal suffers a delay of 54 days. This is stand down, admit, call for the trial court record. One of the offenses is shown to notice to the informant of the victim and shown through the quantity again at this to us the reported on behalf of the
Delay content.
Yes. Next.
20.
Yes.
40 can pass over.
Pass over. Yes.
21.
21 Miller.
Yes.
The first writ petition or dispose of, your lordship, kind of glance page 48.
What are you seeking here?
I am challenging the jurisdiction, the first the proceeding before the district consumer that was challenged on the ground that Honorable Apex Court held in UP Power Corporation and Anisha Hama that consumer commissions have no jurisdiction. So for assessment issue is concerned. I am placing the judgment, your lordship.
No. First time. You approach this court first.
Proceeding that was challenged before this honorable court.
Let us see.
This honorable
Where
court,
is that order?
page 48, your lordship, operating part.
Which
Paragraph 7.
Annexure.
Annexure 6.
Yes.
Your lordship, operating part is page 48.
Yes.
Paragraph 7.
In this writ petition, what have you challenged?
That after the passing of this order by this honorable court, that is the jurisdiction issue was taken, maintainability of the consumer complaint was taken up by the district consumer.
Let us see operating part. What does it?
And hold, your lordship kindly.
No, let us see the operating part. Upon hearing the counsel of the petition, this court might be required to examine the issue of maintainability.
Yes.
And thereafter, the
commission take up the maintainability issue at first instance.
What is the order now?
Now that commission hold that it has no jurisdiction so far the assessment related issue is concerned.
Yes.
Still then has passed the order going on merit of the matter has passed the
maintainability on the
maintainability hold that it has no jurisdiction.
Let us.
Yes, your lordship kindly glance the page 53.
50.
Annexure 7, page 53.
Yes. Let us see.
Discussion and finding. Paragraph 8, your lordship.
Paragraph 8.
Discussion and finding.
Yes.
The first and foremost question is whether this commission jurisdiction to entertain the present complaint.
Taken by the judgment in Supreme Court in UP.
The law on the
Corporation so electricity so proceeding relating to section 135 to 140 of the state constitutes a consumer dispute and consequently falls outside the jurisdiction of the consumer forum. And therefore, the commission cannot examine whether the commission so taken. Thereafter, what happened?
Then hold that it has no jurisdiction.
Yes.
Still then proceed on merit. And hold that
while challenging the assessment order 120 itself is not maintainable. The allegation relating to procedural absent considering the
it has no jurisdiction.
Maintain non-consideration of grievances and denial of the fair hearing are maintainable for limited scrutiny.
Question is that once it hold that there is no jurisdiction to entertain.
No, but what he says,
Complaint.
accordingly, the challenge to the assessment is not open.
Not a.
But the allegation relating the procedural lapses, non-consideration of grievances, and denial of the fair hearing are
With regard to that assessment proceeding, how can he tell to with your lordship?
Why don't you go to State Commission and tell that?
The State Commission, that is there, your lordship, appeal provision is there. I don't dispute on this.
Then why have you come to?
Question is that the commission repeatedly they
You answer that first. Why can't you resort to the statutory remedy under the Act itself?
my submission to that effect, your lordship, that your lordship knows that the read jurisdiction when the order is passed without
Maybe
jurisdiction.
in the extraordinary jurisdiction situation only the read jurisdiction. is
Without
required.
jurisdiction.
Not that every small matter you come to read jurisdiction.
No,
Then the statute is redundant then.
No, that we are not coming in every matter, your lordship. Question, once the apex court held that it has no jurisdiction at all, how can the commission will entertain? We are raising the point that it is not.
Same thing you can argue before appellate court.
That we
Who
can
stops
raise.
you? Who stops? Why
That-
should a writ in an extraordinary jurisdiction, writ jurisdiction? The High Court is as it is overburdened. Why are you coming here?
That is the
Time bound direction I'll give. Go and file. State Commission. Time bound. And if you
But
need
because
the
that-
interim order, you tell me.
that because that limitation is concerned, the commission that what you I am placing not say the commission now or the suppose state commission is saying that since the High Court has given liberty to entertain the appeal, we will only entertain the appeal. So for limitation is concerned, we will impose cost. Because when the order is
I don't know. This is the imaginary situation. I don't know. In your case, if
that is
anything
their
happens,
view,
if
Your
anything of that sort happens, you tell me. You imagine things.
No, that is their view also.
You show me one order like that.
They
Show me one order.
have not.
You may be imagining things.
They have not.
You may have an apprehension, but show me one order. On the basis of apprehension,
They
I
have
can't.
passed any order, but their view and differing matter to some other. That is the.
I will give you liberty. I'll give you liberty. Right. Petitioner earlier approached this court by filing writ petition civil number 10518 of 2026. This court will dispose of the writ petition inter alia observed as under para 7. Pursuant to the directions issued by this court to the District Consumer Redressal Commission to decide the question of maintainability of the complaint case, the district forum entity district forum passed the impugn order dated 25/6/2026. Although the district forum arrived at a conclusion that which part you have point out? Conclusion that the challenge to the assessment made under section 126 of the Electricity Act 2003 itself is not maintainable. However, the allegation relating to the procedural lapses from non-consideration of grievances and denial of the fair hearing are maintainable for limited scrutiny by the consumer. The petitioner has made a grievance out of the observation and submits that having arrived at a conclusion that the consumer dispute is not maintainable insofar as the assessment orders are concerned. The trial courts, the district forum went ahead and entered into the merits of the case. To that extent, the impugn order is bad in law. Besides that, the counsel for the petitioner had also raised several ancillary issues on merits as well. I am of view that the statute provides a appeal remedy. the jurisdiction of this court are 20 cannot be available to the petitioner. Hence, the only course left for this court is to grant liberty to the petitioner to oppose the state's function by filing a appeal under section 4 of it is expected that the state commission shall entertain the appeal on merits without by condoning I'm just writing by condoning the delay in filing the appeal and decide on merits. However, the petitioner shall move an application, a formal application for condonation of delay along with the appeal, along with the appeal within a period of 1 month. 1 month, 1 month will be sufficient. I have condoned the delay also. Merits it has to be gone into. I have said that by condoning the delay, the state commission has to enter into the merits and decide.
Violent.
Then your apprehension is
that we are facing problem.
Yes.
And one read appeal also, Lord, see that this honorable division was also held in the read appeal that the commission has no jurisdiction.
That's right. You now apprise the court, but the district forum says that as far as the assessments are concerned, no jurisdiction. But the manner in which you have treated it, that there the deficiency he founds. And passes the order.
But he cannot,
What else? If anything relatable to assessment, you can't entertain the petition at all.
Exactly.
That's your case.
Yes.
You will succeed. Yes.
Next is also same.
22. Same. Kar do. Change kar do.
The certified copy be returned back.
Certified copy of the impugn order we return to the petitioner, replacing the photocopy. Yes. 23.
Yes.
Yes.
The appellant seeks to challenge the order of acquittal dated 12/5/2025.
Yes.
Acquitting the present respondent number 1 along with 7 others only solely on the basis that the grounds of non-compliance of section 42, 50 and 50.
Where is the perversity? Which finding of the trial court is perverse according to you?
Pilot may submit the brief. I want to state the brief fact.
Forget about the fact. You show me the perversity. You seek leave to appeal.
Yes,
you have to satisfy. If they're perverse, then only I'll entertain. Why honest? Otherwise, why should I? Leave is not by way of routine. You have to satisfy. It's in a case of it's a judgment of acquittal. If the state is aggrieved, you have to show me the perversity.
Section 42.
Yes.
Speaks, my lord. Power of entry, search, seizure and arrest without warrant or authorization, my lord. Lord, you may kindly see the accused.
It seems you have not prepared in that line at all. There is no compliance of 42. There is no compliance of 55. There is no compliance of 57. That's the finding.
Compliance already.
Show me that the findings are perverse because in fact it was complied. Show me that and I will entertain. The findings are very detailed findings. So prepare and come. Yes. Next. 24. 25. 25. 24.
23 allowed. 25 pass. Arjuna is 25.
25, your lordship have filed an application for substitution also. During the pendency of the appeal, the appellant has died, your lordship. Filed the legal error along with the death certificate of the appellant. Why? Lordship may kindly allow this application. The entire pensioner benefit is in step.
Who are the legal heirs? Where the IA number? Yes.
IA number 2084 of 2020.
Who are the legal heirs?
Well, that's the wife along with, one wife is, filed the IA, my lords. Legal certificate is
Appellant is Ramakant Mahapatra.
Yes, your lordship. Ramakant Mahapatra is deceased, your lordship.
This is appellant.
This is appellant.
Rajalakshmi, where have you said that you are the
Rajalakshmi Nanda has filed an application for substitution. Is the widow, my lords, of the deceased.
where is the abatement order? Order of
Has
abatement?
not been abated, your lordship.
Not yet abated. Yes. What do you say? Vigilance.
Yes, your lordship.
Nobody is there. Okay.
Since 2016, this matter has not been listed.
Okay. By way of this application, under section 394 CRPC, read with chapter 6, rule 27, A of Odisha High Court rules. The applicant seeks to substitute herself in place of her deceased husband, who was the sole applicant in the criminal appeal number 76 of 2011. For the reasons stated in the application, you come to the 117. The other LRs are also there.
Yes, your lordship.
Okay.
Daughter and son.
Applicants seeks to substitute themselves in place of the deceased appellant. Mr. Porigar, the council appealing for the proposed appellant also submits that the appeal was lastly listed in the year 2000. It was 2016. Thereafter, the appeal was has not been listed subsequently. The appeal has not been abated, even though the deceased appellant had died. Regarding it to the submission made by Mr. Porigar and counsel for the appellant, the application stands allowed. The LRs of the deceased respondent be brought on record for the appeal. Demanded more parties to be filed within 2 days. Within 2 days, release the appeal in the weekly list. 2011. Weekly per year. Yes.
26.
26. Yes.
26 also here may not same prayer. In fact, during pendency of this.
Sorry?
Here also same prayer, my lord, as like the previous item. Here during pendency of this criminal appeal, the appellant has expired and his wife is willing to pursue the case. Therefore, I have filed.
It has been abated or no?
No, not abated.
Right out. Same कर दो. Same order कर दो. And be wife, wife,
Wife, my lord.
Yes. Same order कर दो. The deceased is the husband.
Husband, man.
Is the husband.
In the prayer portion, I have clarified the details of the wife, my lord.
Yes. 27. Saraswati Ghosh.
Saraswati.
City applicants, right? And the only applicant. Wife. Yes.
27.
And 26, there are 2 appeals. Both the appeals.
Second, first sub-item, some other advocate is.
Sorry?
In the sub-item, some.
Speak little louder. Are you?
In fact,
After lunch, you will come.
In the sub-item, some other advocate is appearing.
But see, same Pradeep Ghosh.
Pradeep Ghosh, but that is for confiscation and the present one was for conviction, my lord.
You don't want to substitute there. You have to substitute. Confiscation is more important.
I do understand, but the brief has been transferred from us. Mr. Mo.
Do it. Otherwise, see, confiscation is much more important.
My lord, I do understand, but that brief
We'll
has
see.
been
Anyway,
transferred.
good record though. Second record. ठीक है. Yes, next.
27.
27.
Yes.
The appellants are already substituted in this case, my lord.
Mm-hmm.
Let's fix a date for hearing. Already LCR has come.
These things.
I pray.
HR has come. Yes,
Orders.
including the weekly list for hearing.
May I be
Yes.
pardoned to LCR may be provided.
Yes, Mr. HB.
My lords, I am appearing in all these 25, 26 and 27 matters.
Okay, okay. I have Mr. HB something else. Yeah,
I
okay.
pray, my lord, LCR.
And first two matters only substitution, and the second one, the 28th has to be included in the weekly list for hearing. Okay.
My lords, my lords. my lords.
Yes.
So
My lord,
grateful, my
I pray for providing me for LCR, my lord.
You take it from here.
Yes.
Yes.
28.
29. 28.
Interim bail, my lord. The inside custody 7 years 8 months, my lord.
Yes.
Due to illness of his mother, that one I had to take instruction.
Instruction has not received, my lord.
At 27 and 79, 2 occasions they have taken time.
29/7/26 the order.
Thereafter 17/8.
What is the problem? 2 dates.
Letter has been issued, they have not signed.
He is seeking for interim bail.
Yes, my lord.
29/7/26 direction was made. You sought time once again on 17th 2026.
Through WhatsApp, I have also sent message and calls.
Right.
They have not.
The order dated 29/7/26 as well as 17/8/2026 has not been complied by the State Council. He seeks last and final opportunity to comply. The same release the matter on 11th of September. Yes.
29.
29 custody certificate and also antecedents.
Appellant convicted under section 41C of the NDPS Act. Already in custody 5 years, 8 months, my lord.
Sentence period?
10 years, my lord. Custody certificate.
You are already 10 years.
Yes.
Out of 10 years, 5 years.
5 and 9 months.
4 months.
You are involved in another case.
No, my lord.
Yes. Report is there. What to do?
I think only this.
Involved in Oskalongo PS case number 142.
This case, my lord. This case, my lord. No answer. First offender member.
From the available PS record. This is the same case 140.
Yes, yes, my lord.
Let's see.
The first offender.
Pursuant to the order dated 3/8/2026, the report has been dated 18/5/2026 by Superintendent Khatri Kivapra. Which indicates that the appellant has already undergone 5 years, 4 months, 21 days actual custody, and the jail conduct is satisfactory. However, the incident certificate furnished by the IIT Oskalongo PS, it is 28/26, is not submits, except the present case. There is just see, this is Oskalongo PS case only.
142.
142 2020.
Nobody is speaking of that.
One.
Except the present case, is not involved in any other case. Yes.
Yes.
Minutes taken under.
IN number 991 is the interim application. The already infractors were kindly permitted to
Which
withdraw.
one?
991.
991. Yes, merits. Merit, have you prepared or not? Yes. Merit, have you prepared the matter? Have you read the evidence?
No, madam.
This is the matter on 30th of September. Yes. Thank you.
30.
Notice has been issued.
Custody certificate. Have you got it? Custody certificate.
No, no, madam. Not.
Order dated 10/8/2026 has not been complied. It was up to State Council 6 1 more week time to comply with same. Let him do so. Please the matter. After release the matter on 22. What is the sentence?
10 years.
Sentence 10 years.
And about 9 years in court.
Out of
10 years.
release the matter on 18th September.
Hospital certificate of the called for.
Yes, yes.
31.
Sorry, madam, sorry.
May I please?
Custody certificate is there. Sorry.
Why don't you prepare little?
No, it was
2 minutes before.
kept, just in another file.
If this is the way you conduct, then I can't finish the board.
8 years, 6 months.
9 years. Sentence. Show me the sentence.
10 years.
10 years, madam.
Page 36.
The problem is I even can't rely the way you people assist. I have to read everything. 6 months.
Custody period.
This is item number
Remission.
30.
30.
30 then?
Custody period including remission 9 years, 2 months, 25 days.
33 0. Very bad. Madhav, Hon'Ble, Madhav. 1. Who is appearing for victim? Victim? You are appearing?
No, madam.
Will you not point out this is a POXO case?
Notice already, sir.
Okay. Apparently the order dated 10/8/2026. Custody certificate dated the ACR of 2020 has been received from the superintendent. One of the convicted author, which indicates that the exam is already undergone 9 years, 2 months and 25 days custody as on 23/8/2026. And the jail conduct appeal is satisfactory. It appears to be satisfactory. And this is taken on record since one of the offense involved in the present case. Six POXO is there, no?
6
POXO. If you notice the also, written rules also, least the matter on 8. Yes.
Notice already solved.
Yes.
31.
18th.
Already.
18th.
May I please, Lord?
Yes.
The public against Malado, the section of 6 of POXO and 372N matter.
Notice. Notice. POXO is there, notice. In the meantime, call for person technical code conduct and anything else. Yes. 32.
32.
I have filed one interview application for bail, my lord. I have filed one interview application for bail, my lord.
That's right. I'm meeting notice here.
Madam.
Yes.
Obliged.
For 7 years, my lord. Not to my page 54.
Application.
06 for conviction.
Of,
Out of my lord, 7 years, more than 4 years. Left. Page 48.
Yes. Yes.
After my 7 years, more than 4 years in the custody, my lord.
I'll call for a custody settlement. Call for custody settlement. The contactants also release the matter on 25th of September. Yes.
33.
Yes. 33.
Notice is,
Yes.
notice is sufficient.
Not sufficient.
Yes, Lord.
Offense.
POCSO 20 years, Your Lordship.
Despite department go.
Item 33, Samapika Mishra is appearing, and today morning his father just fell down from the stairs. So she
Simply
may-
adjourn. Simply adjourn. Simply adjourn. Yes.
34.
In this case, conviction is staying near my lord.
33. Sorry.
33. Samapika Mishra has some problem. Yes. 34 years.
May I please your lordship, in this case, one interim bail application filed before your honor, my lord. The petitioner is in jail custody more than 4 years.
Interim bail.
My lord,
IA number 2135.
my lord.
Ground.
Well, one medical certificate also attached here with
Father of the petitioner.
annexure A, my lord.
Father of the petitioner is
My lord,
suffering.
my lord.
This is IA number 2135 of 25. This is an application moved by the appellant seeking interim bail on the ground that his father is terminally ill and needs immediate medical attention. He has also filed that medical document with the application. Issue notice, extra copy of the application be served to the State Council, which shall obtain instruction regarding the same. Release the matter on 21st September. Yes. Yes, next. 35.
Petitioner, my lord, in this case, my lord, kindly custody certificate be called for my.
In the meantime, custody certificate will conduct as well as the.
Highly obliged.
Yes.
35.
Wait, please wait.
Yes.
Conviction under section 6 of the POCSO, T63.
Service. You are appealing?
My lord, I am appearing for the informant. We have only received the notice and copy is not solved. Kindly, my lord, provide 1 week time period to file the objection.
16/1/2026. So entered appearance of the victim informant and submits that we then have the copy of the appeal paperwork or the application. Let the council appeal for the residents and supply the same. Release the matter. Release the matter first week of October. Yes.
But on the last occasion, custody certificate as well as conduct certificates and everything has been called for.
Custody certificate, jail conduct as well as the incident of the evidently of someone. Yes.
36.
We may be permitted to collect the TCR in the soft soft copy of the TCR. We may be permitted.
Yes, it is standing order, no problem. Yes, next.
36.
Conviction equivalent 10 years, custody 7.5 years, my lord. I have 2161 for bail, my lord. Contact and.
We called for court. Notice.
Notice I inform.
I am appearing for the informant, my lord.
Custody contact, my.
The custody conduct and independent. Okay. Yes. Give your appearances. Yes.
37.
Conviction on the books address. Notice already made
Sufficient.
and he was bail during trial. The victim is my lord PW4.
Pursuant to the when notice was issued.
8824 order plus.
Notice sufficient.
When was it issued?
My lord 8824 order, my lord, can you have a glance?
So 824 the notice of the problem there.
While the
Pursuant to
jurisdiction
the
of
order
the
dated 14/7/2025, notice on the receipt of this informant has been served. The proof of service.
Yes.
Proof of service has been placed on record by the State Council. However, none has entered appearance on behalf of the victim of the informant, and so is appointed as amicus curiae to assist the court. Madam will come and appear. Give the name. So is appointed as amicus curiae to assist the court and take the soft copy. Soft copy. What is the sentence?
sentence is 20 years.
20 years.
PW4 is the victim.
How much you have undergone?
3 years some.
October. Yes.
Khali matter में for custody certificate.
Even custody certificate देख पता table
and conduct.
Also the court. The
conduct.
So yes. So council appointed amicus curiae shall be supplied with the soft copy of the entire record. Yes. Take entire record, madam. Yes, get ready. Yes, next.
My lord, item 36 I have already uploaded.
Yes, I have. Yes.
38.
Last
Yes.
date, my lord, the custody certificate was called for.
Yes, sir.
You got it?
At the time of incident, this appellant was a juvenile. And
Yes. He was the offense?
my lord, he was convicted for 10 years for the offense punishable under section 18 of POCSO. my lord.
Notice has not gone?
Yes, notice sent.
Who is appearing? Service देखो.
Yes, sir.
Service is complete.
Yes.
Madam. Pursuant to the order dated 10/8/2026, the jail superintendent Sundargarh has filed a report dated 17/8/2026 in Premier stating that the appellant is undergone
6 years, 6 months, 42 days. 6 years, 6 months, 42 days.
22 days, and his jail conduct is also stated to be satisfactory. A notice was already issued to the victim, public informant, and service proof of service.
Yes, yes.
Proof of service is placed on the court by the state court. However, despite service, since none has appeared for the informant of which also, for medical video, we need to do some media. So, funded amicus curiae to assist the court. Yes. 39.
My lord.
He appointed amicus curiae. Yes.
On behalf of Mr. Chandra, appellant, my lord, taken on next week.
October.
Custody certificate.
Custody certificate. Call for custody certificate. Yes, next.
Sir, 40.
Yes.
Well, the use of murder for 10 years, 4 being murder. 10
Hmm?
years conviction murder.
Yes.
4 murder.
Service. Who you are appearing?
No. 4 murder.
Who
2 years
is
conviction. It was 74 murder.
Service therefore? Huh?
No.
Service sufficient?
No, not SC murder. 304B.
But notice was issued. Written objection. Bail application. Atul Tripathi, State of Orissa, all these things are written.
Item 40.
Huh? Item?
40.
40. Just see the proceeding. Proceeding dated 31/1/2025. Just see the proceeding. You read the proceeding.
29 1 murder. Notice murder. Question of bill was sought to the state council for murder. All of those things.
Convicted for 304B.
Yes, sir.
So why these proceedings?
State council was directed to file objection. Murder.
Yes, are you filing?
Yes, sir, already filed.
Already filed.
Motion call for the murder.
Yes, objection is there already. Yes. Yes. Let us call for the custody certificate and all.
Yes, sir.
We'll see that. Yes.
Out of 10 years, around 5 years, my lord, more than 5 years.
Out of 10? Okay, yes.
41.
Yes.
Offenses under section 307, 394 and 34 IPC. Punishment is 10 years, rigorous imprisonment. Out of that 10 years, Lordship, he has been in custody since for the last more than 5 years.
The total sentence, how much you have undergone?
5.5 years, nearly 5.5 years.
Yes, surrender certificate, because he was on bail, my lordship, and the
Interim
criminal
bail.
antecedent sick for my lordship.
Yes.
8 criminal antecedents.
Therefore, I'm asking for
With
that
the
report.
same similar offense, ma'am.
Get that report. Already report is there. 41, huh? What do you say? So many antecedents. So many antecedents.
And here is the case.
Although, Lordship, I do not have the record of the exact status of that antecedents. If copy may be served, I may apprise them.
The State Council, while opposing the bail prayer for the appellant, submits that the appellant has as many as 8 criminal antecedents. A report of conducting case, the IIC conducting case, they said 18/1/2026 is released on the copy of which has been supplied to the council against the appellant, who shall file a comprehensive affidavit. Leave the matter of 2nd week. Yes.
42.
Yes. 42. Yes, 42, madam.
42, 498, 304B, my lordship, 10 years of conviction, 4 decade is also there. Father-in-law, mother-in-law, and husband is there. 2 petitions are there.
Yes.
Miss Nirupa Saw is the husband.
Get the custody certificate. All the 3 appellants. Yes.
43.
My lordship, one request, my lordship, that may be mentioned in all the criminal appeal, because when we are sending to the jail superintendent, they are saying in the connected.
All the matters.
Yes.
In the
43 kindly pass over, madam.
pass over. Okay.
44.
Yes.
Appellant has been convicted for 10 years for the offense under section 376(1). And he is inside the custody since 11/2/2023.
Let the certificate come. Yes.
Yes, sir.
45.
Appellant was convicted for 10 years for the offense under section 376. Is during custody.
46.
46.
May I please last? In the last occasion was sought for the custody certificate.
Yes, my lordship.
Got it?
Yes, my lordship. Of Nitish Kumar, I have already resolved. My lordship, given to the.
Convicted for 10 years. After 10, already on near about 5 years. That is.
No, 4 years, 11 months, 23 days.
Going to be covered in 30th August.
Okay, it's all right. Give me.
My lordship, I have.
Then sentence is
10 years.
10 years. 20B to C, my lordship.
conduct.
Conduct.
Antecedents.
Antecedent, I have not received, my lord.
Then you have to get the antecedent is important.
Yes, my lordship, in that one.
That must be in my state.
But it is already 3/8/2026, although custody certificate has been received by the State Council. However, the criminal antecedents up to the appellant has not been obtained from the central police station. Therefore, he seeks to stand for the law. Yes.
Yes, we will fix the death.
Yes. Next.
47.
May I please, Your Lordship? In this case, my lord, 7-year conviction. Out of 7 years, 5 years, 5 months, 22 days already undergone. Last occasion.
Got it, madam?
No, my lordship.
12/8/2026 has not been complied. The State Council seeks the last opportunity to comply with same. We should matter. Yes.
48.
Short date may be fixed. My lord.
Yes. 48.
Convicted for 7 years. Under 376, 7 years, and already custody for 2 years, 3 months. was bail during the trial. my lord.
I'll call for this particular.
49.
May I pardon? Pardon. May item 42.
49 is going.
Yeah, I'm sorry.
I don't know 42 whatever.
49 mallet.
42 going. Huh? Report. I'm called for report. Yes.
The first is the father-in-law, second is the mother-in-law.
What
They were thrown on bail.
I called for the report. Yes.
49 custody certificate we called for because earlier he was on bail.
Yes, madam.
No, my lordship, it was not called for.
Not
It
called
was
for.
in.
Not called for.
Custody and conduct mallet.
Yes. 50.
50.
May I please? 10 years conviction on the section 376(2), my lord, and three years conviction under section 363.
Call for the secretary.
My lord, LCR available.
LCR is called already.
My lord.
LCR is there. TCR is there. Yes.
51.
51.
There are objection was to filed by the state on limitation.
Hmm.
There is a limitation to 79 days.
79 days in filing AP.
No, 280
days.
280
days.
I am condoning the delay. For the reasons stated in the application, the delay of 280 days in filing the appeal stands condoned. Appeal admitted. All parties here. Admitted. Yes.
46. May please, my lordship, I mean, lordship, item 52, lordship. It's an appeal against statute. Yes, ma'am.
Yes, 52.
Yes, my lord. It's an appeal against statute, lordship. That initially the offence was registered, lordship, under section 341, 323, 506, 34, and
52. Opposite party number, respondent number 224. 224. Notice of the case. Process fee is to file within 1 week. Yes, next.
Directful, ma'am.
376, 6 POCSO was there.
Yes. Yes, 53.
Under section 376(2)(n) of the Indian Code,
Informant.
sentencing him undergo 21 years, 3 months, 17 days.
21 years.
Yes, ma'am. 3 months, 17 days. To
You
pay,
had undergone?
my lord,
How much you have undergone?
more than 15 months.
More than 50?
15 months.
15 months.
And he was released on interim bail for marriage also. That they have conciliated between them.
Oh, let us get the certificate. Certificate, the conduct and NDC. Yes.
So with the conduct also.
Yes.
54.
High Court conviction on 307 minor. 4 offense filed and 4 accused persons on bail.
But what about your criminal antecedents? We have.
No one.
No. Yes, what do you say?
File is not with me.
Last time I directed to verify the whether the same putting is Nagu or not.
If there that is the same putting.
Sorry?
Same putting.
Same putting.
That I have verified. File is not moved but same putting.
There are how many accused?
5 accused convicted, 4 released on bail.
Right. And co-epid persons have already sent the very equivalent. Yes.
55.
55 notice has already been issued. Section 6 is there. I humble submission, let it be sent through local policemen.
IAC notice. Through IAC will serve.
Through IAC. Although notice were directed to serve on the informant of the victim by order 22/7/2026, but no report of service had been placed on record. Therefore, the state council to take steps to serve the informant of the victim through IAC. Least matter of yes.
56.
56 will pass over on behalf of
Pass over will the jail custody and conduct.
Yes.
They amputed both the hand.
Let us get it changed. That we should present here please. Yes, next.
57.
May I please the lordship, my lord? If the magistrate table offense matter consecutive sentence 11 years
Maximum is 5 years, my lord. Last time, my lord, is pleased to call for conduct and custody, my lord.
Have you got it?
Yes. This is hell, my lord. I have lodged an FIR against one Benin Naik. In that case, he has been convicted.
ଗୋଟେ ବର୍ଷ 8 ମାସ 21 ଦିନ.
Huh?
1 year 8 months 21
Out of
5 years.
out of 11 years.
11 consecutive, my lord, this will be taken as 5 years now because 5-5-1.
Consecutive?
Yes, consecutive.
Let us see. Let's see judgment.
Because of keeping in view the age of the victim, perhaps the trial court has a consecutive.
Can't be consecutive. Concurrent. 5 years.
1 year 80 months.
1 year 80 months. So,
the victim is 1 month.
And I lodged an FIR against one that Benin Naik. He has been convicted. And after his release on bail, this case in convict after 3 months, 3 years of the
lease suit 11. Yes. 11.
Well,
11th.
I am for bail, my lord.
Bail for bail only. Yes.
Two year 4 months 19 days in custody.
3 years.
2 years 4 months 19 days. Out of 5 years.
Out of 5 years.
Victim is 8 years.
Yes. Informant. Appellant is not there. Non-appeals for the appellant, least matter on. You say 5 years, out of 5 years, 3 years.
2 years 4 months 19 days.
Least on 30th. Yes.
59. May it please your lordship. But here conviction under POCSO Act and 3762N and 3763. Young boy incarcerated for 20 years.
This has gone.
Yes, yes. Informant had appeared.
Tapan Jyoti Pan has already appeared. Yes.
2 months I was released on interim bail. I have already surrendered. Surrender certificate is with your
I'll
lordship.
get the custody certificate, jail conduct, and the antecedent.
They do interim conduct.
Only one thing I would like to draw your lordship's attention. There is no evidence worth mentioning even for 20
Let us
years.
get the custody certificate
Yes.
because you have gone in interim bail and all. Let us understand.
Yes.
Yes.
60. Your lordship may fix a date.
Yes, give it. Fix it.
So item 65 POCSO 6 is there, my lord. Notice may be issued.
Notice.
POCSO 6 is there. my lord.
Notice has been issued.
No, my
Notice
lord.
1 na 25 रे.
Notice was issued.
Notice was issued. That proof of service we have to. Proof of service we have to.
It's there.
नहीं आसी नहीं.
Okay. Although notice was issued to. No, notice was not issued basically.
Notice.
See, notice has not yet been issued.
एक नोरे आम्बट আছে.
Delay is there. I'll condone the delay and admit
Delay
it.
condone 18 add करो. 18.
The delay of 37 days reported by the staff reporter and filing the appeal stands condoned for the legal. Admit all for the records. Since one of the offences is also issue notice. To be served to.
Convicted for 20 years. 376.
This is health sufficient by the mother of the victim.
Despite service of notice to the informant of the victim, none has appeared. Yes.
Custody certificate.
Yes.
Oh, 62 date.
Give.
Please, your lordship. Petitioner has been convicted on section 376 and sentenced to RI for 20 years and 506 sentenced to RI for 1 year.
Let me get the custody certificate.
He was on bail throughout, my lord. Bail granted by this court
Okay.
since 11/9/2019.
Since the date of judgment, he is in custody.
And the observation while granting bail then was that the letter of the IIC Chandipada indicated that the victim was not interested to marry the petitioner and no DNA test had been conducted.
Okay. Let us see the victim evidence.
Victim states that she is mentally retarded.
Oh.
PW2.
That's the problem.
PW1, my lords.
PW1, huh?
Yes.
Yes.
He has
And the victim
stated
informed no accused.
in the first paragraph, my lords may see you may look at the fifth line.
Yes.
She doesn't say that it was against her will or against her consent.
Again, he has to
Detain me, took me to the nearest bushes and committed sexual assault on me. At that time, no one was at the spot. Thereafter, also the accused committed sexual assault.
There are two Supreme Court judgment in one judgment I have also.
Yes, convicted under section 20B2 C, Lord.
You also 63 and frame one in time for the report.
Okay.
Bring for 1 million.
Order dated 29th of 2020.
1 million.
64. Information rejection matters.
Yes.
Notice only sufficient against the informant.
Sufficient. Are you appealing?
I am appealing.
Yes. Pursuant to the order dated 8/12/2025, notice has been served on the victim with the informant whom so entered appearance and files Wakalasama. Are you ready?
My lords, in the meantime, my lords.
Are you ready? Sorry, are you ready?
Well, in the meantime, the matter has been compromised between the parties.
Yes.
Between the informant and.
Yes. Should be directed to I will file the compromise petition, my lords.
Entered agreement, file Wakalasama. He further submits that the parties have entered into agreement, so therefore he is satisfied in the affidavit to that effect, leave the matter. Yes. File the affidavit. Yes, next.
65.
Yes, madam.
Trial court record has not received.
Trial court record has not. No, 65. Trial court record has come on this. Offense?
Office may not go. 376.
Yes, sir. Under section 71, 351 2 of BNSS.
Yes. Yes.
66.
Thank you, Your Lordship. In this case, last occasion, Lordship directed to the State Council to obtain whether the appellant has two minor sons are living alone and left her wife. The appellant's wife already left after conviction.
Custody certificate not received.
Yes.
Custody certificate not received. Objected, no, custody certificate is required in this.
No, last order just see. Last order I asked you to get information regarding the two minor sons. Have you read the last order?
On date 27/7/2026, ma'am.
Yes.
27/7/26.
Yes.
Thereafter, no letter has been issued.
The order dated 27/7/2026 has not been
This is
complied with
jail
the
ban.
council. She seeks final opportunity to comply with him. Please the matter. What day is the 25th of September, yes. Yes. 67.
My lord. Appellant has been convicted
2 years.
to 2 years for rigorous imprisonment
Right.
under section 12 of POCSO Act.
9 years, 9 months in custody.
10 months, 10 because during
Notice
under
is-
trial 1 month.
Anyway, notice has to go.
Notice was issued.
Huh?
Earlier notice was
Notice-
served.
Yes, madam, notice. Third.
Notice not held sufficient, but
But out of 2 years, my lord, 10 months.
Although by order dated 8/1/2026, notice was directed to serve of the informant victim. But the service report has not been placed on record by the state council seeks final opportunity to serve for the informant or victim. Release the matter on 16th September without bail. Huh? Short sentence, madam, you have to get it. 2-year sentence. Yes.
68.
May I please, my lord?
Yes.
The appellant has been convicted under section 21C and sentenced to undergo RI for 10 years. Out of 10 years conviction, the appellant has remained in custody more than 6 years. This coordinate bench has granted interim bail for a period of 3 months on 9/4/2026, which was going to expire on 17/7/2026. On 17/7/2026, due to viral fever of the petitioner, he could not surrender, and the time petition was filed along with the medical certificate.
Now you surrender.
I may pardon what I'm coming. On 17/7/2017, the learned trial court issued MDW and could not reflect regarding medical certificate. On 22/7/2000, when I went to bona fide, then I want to surrender. The learned trial court could not accept me. I only sole prayer to accept my surrender certificate within a period of 2 weeks from today.
Then council, Ponda, council submits that the pursuant to the interim order. Where is the interim order? Dated?
Interim order dated 9/4/26.
2026. He intended to surrender. However, the trial court below not accepted the application for surrendering because of the delay. Because of delay in surrendering. He further submits that before the expiry of 3 months period of interim bail, he had already moved an application before this court. He exceeded enough time. How the application could not be taken up. The delay in surrendering has been duly explained in the data. Be that anything, the petitioner, the appellant convicts surrender within a week and file a report. It is made clear that no further symptoms are being able to state for this.
And I may pardon.
So, name district has already been surrendered for the court.
Where did he surrender?
Certificates and need some time to file the certificates.
I am for the my lord
Second.
Savite.
Which item?
81.
Sub item?
81.
This is the first one is yours, no? Second one is yours. Second one is
CRLA 1/10/26.
yes, second one.
81.
81. Current schedule. Also for the appellant seeks 1 time to file surrender. Yes.
I am Savite on 3 man.
Yes.
159/26. CRL, my lord.
What do you want?
I have already surrendered in due time, my lord. 17/7/26.
Certificate you filed?
Yes, sir. Certificate.
Leave the matter.
And I may pardon, instead of 7 days, 2 weeks.
No.
Okay.
One
I'll list it after 10 days, madam. So that you know.
totally. Next.
69.
Madam, I may pardon, item 83, conviction is
79. I'm there. Wait. Yes.
69. Convicted on 304 part 2 is sentenced to 5 years. Custody. The custody certificate appended in the judgment. I mean, continues since April 2022.
April 22 to
I mean, custody.
25.
Yeah. So on the date of judgment. That is 2/4/2020. I am continuing except that I was granted an interim bail for some period 2 months.
So it comes to how much?
Malata more than 4 years, 2 months now.
Out of 10 years.
5 years.
Okay, let us see.
Sentence, my lord. 304 part 2, 5-year sentence.
Petitioners, the appellant has become convicted for offence under sentence to undergo RI for
5 years.
5 years.
Fine of
5
rupees
years.
10,000 in undergo further RI for 6
The
months.
counsel appearing for the appellant taking this court to the front page of the impure knowledge submits that during the trial, throughout the trial, the petitioner was, the appellant was taken into custody on 2/4/2025 and he continued in custody up to date, up till date.
He was granted interim by this court. Surrender interim, surrender certificate also filed.
Interim bail. However, when the appeal was filed on this court on 11/5/2026, the
All the injuries are at this case.
interim
As per the doctor.
interim bail for
2 months.
2 months.
2 months. Surrender certificate.
After revealing the interim bail period, he has already surrender certificate has already been filed on the court. Surrender on 15/7/2020. Out of the total period of awarded period of sentence 5 years, the appellant has already gone 4 years. How much it?
4 years, 2 months.
4 years.
Including that interim bail period.
Since there is no scope of the appeal being heard in the near future, so also granted. Yes. Next.
70.
Fine state. Fine state.
And of 70 by lord, notice informant not held sufficient.
Not sufficient.
Issue.
Already continue near about 7 years.
Notice is to go.
Repeated.
To the order dated 17/4/2026. Although attempts were made to serve the notice on the informant of the victim, but it appears that notice is not sufficient. Therefore, the state council takes action to serve the informant of the victim through IIC and file a report. What is the sentence? Total sentence?
376(3) arrive for 20 years.
20 years. Okay.
Already confirmed.
Section 4.
Meantime,
Section 4 of POCSO Act.
As well as the antecedent of the appellant we also count for. Yes, next.
71.
7th September. Arata.
Huh?
Out at 7th September.
Let it come.
7th September.
So,
71.
Yes. Service.
So notice not sufficient.
On the pursuant to the order case 13/7/2026, notice on the informant of the victim has not been served. A state council seeks one more opportunity to serve the informant of the victim by form through. Looking to so, please the matter of also meantime, custody certificate, jail conduct, as well as the incident of the appellant we also called for. Yes.
72.
May I please, your lordship?
Yes, submit to also, and we are sending the notice on 5/8/26. Notice and not been.
Notice has not been served. Order number 27, 29, 2026. Yes.
73.
73, sub-item, second sub-item. Your lordship has called for report. I have filed in IA.
Copy of the IA has not
got
been
the
served,
report?
my lord.
Yes, let us.
73. That is second item, we have a report.
Yes. Show me.
That is the CRL number 2285.
Yes. Regarding what?
Yes, my lord.
Seriously ill. Entering bail for a period of 6 weeks on the ground that mother is seriously. Yes.
Mother is ill.
Show me the
The
report.
father is not able to take her to.
Convicted for what?
POCSO
That is the POCSO.
and 20 years.
Who is appearing for?
Young rape case. That is the
Who is appearing for the?
I have for the informant, middle copy of the IA has not been served on me.
It will be out of his own make the local inquiry, certain different health condition of the mother of the victim. Seems to be very seriously ill. This report. Report is there.
my lord, that last for my lord.
Before
Yes.
There are 5 appeals here.
5 appeals.
The first 3 sub-items your lordship has issued notice, admitted them, and fixed the matter to January of next year, my lord, I believe, for a counter.
Second one. Sub-items.
Sub-items 1, 2, and 3.
No, sub-items are not even admitted. Not even admitted.
Your lordship has seen order dated by Sat Chabis.
By such submission, the first item.
Your lordship has admitted it.
Order
number 2.
First one is admitted.
Yes,
No problem.
posted the matter to 24/7/2027.
Yes.
The second and third sub-items, they have also similarly been admitted.
But it has not been admitted as yet.
They all came up on the same day, my lord.
Same day.
My lords, I'm on VC, my lord. I'm for the opposite parties.
And all other matters are not
yet in the first 3 matters have been admitted, and your lordship has posted it to 24/7/2027. Mr. Panda has appeared in those 3 matters on that day, and and extra copy has also been served, I believe. Right, Mr. Panda?
Correct.
In these 3 matters, one IA is pending, my lords. That is for stay of order of attachment, my lords. The other 2 matters, my lords, they arise out of a separate order passed out of the same proceedings. So they have to be admitted. 558 and 559.
And Mr. Panda accept notice. And Mr. Panda entered a bill for 80. Okay. What is the in which matter now?
In 558 and 559.
558 and 559, yes.
Their appeals were dismissed by a separate order. So 2 separate appeals have been filed. So your lordship has to admit that.
Yes, I
A similar order has to be passed. In all these cases, my lords, a provisional attachment order was objected to. Provisional attachment order was confirmed, against which I went up in appeal. And now, since the appeal has been dismissed, during pendency of the second appeal here, my lords, I am praying that the order of attachment may be kept in abeyance till disposal.
What do you say, Mr. Panda?
My lord, my objection is that it will be just like disposing of it finally. Your lordship, it is a provisional attachment. Now, if it is stayed, then they can
it is not a provisional attachment. Provisional attachment has been confirmed.
That has been confirmed.
Provisional attachment order was passed. It was confirmed subsequently. He filed appeal.
Correct.
Thereafter, this proceeding have been initiated.
My lord, I bow down to that. What happened, your lordship, is that Section 5 allowed the joint director to draw a reason to believe and then attach
if you want to file objection, file objection.
Correct, lordship. We'll file
written
an
objection. I lease it for hearing on 11th.
We'll file an objection. No issue.
11th of September. You file written objection if you want to file.
Your lordship.
All
the matters you file.
Yes, your lordship. We'll do that.
Individually, right on. Mr. Panda, then it's counsel appearing for Rajat Panda. Appearing for the AD submission. You would file a written objection to all the appeal. They can do so within a week. Lease the matter on 11th for disposal. 11th.
Yes, your lordship. Obliged.
75.
Yes.
Surrender file, not surrender.
Not surrender.
That is the report, my lord. The report of the
What to do now?
IAC Mahanga Police Station to execute the included order issued by the Lord and Trial Court. This is
Reported.
26 minutes and issued as by the Lord and Trial Court. That may be executed by the IAC Mahanga Police Station.
The appellant has filed the appeal. 75 appeal against the judgment of commission in order of the same was admitted wide order dated 22/7/2020. On that day, it was not pointed out to the court that the appellant, when the sentence was, when the including judgment of conviction and sentence was passed, the appellant was not present before the trial court, since NBW was issued wide order dated 17. Wide order dated 17/3/2026. 2026. 26. Therefore, 26. On the last date of hearing, when the matter was listed, last voting is not there. Monday, Friday, no? Friday, on Friday. So, this court has directed the appellant to surrender and file surrender certificate. The counsel appearing for the appellant submits that the appellant has not surrendered. In view of the same, the NBW issued by the trial court wide order dated 17/3/2026 be executed by the IIC, which police station?
Mahanga Police Station.
Mahanga police station, and file a report. File a report before this court. Please the interaction with the report. The order, this order be communicated to the IIT Hon'Ble Police Station for compliance. So, yes.
76. Conviction for 3 years when notice was earlier issued by law.
Pokso is there.
Yes,
Pokso is there, but you report.
Notice issued. Service?
Notice absent is report not issued.
Right order dated 10/7/2026. Notice was issued to the informant of the victim in the present case. However, despite sufficient notice, as reported by the State Council, none has entered appearance. And Mr. Pradhan, who is the court, we appoint the MH skill to assess the court. Copy of the you give the copy, and we also permitted to take the soft copy of TCR. Please the matter 3 years sentence.
Yes, 3 years.
3 years of
All along bail.
leaves the matter on 9th of September. 9th September.
Pardon your lordship, it's Mahanti, not Pradhan.
Oh, sorry. Right off. Yes.
77. Notice was
Give your
sufficient.
name.
77 Pokso, my lord.
Notice was sufficient, my lordship. Sufficient, my lordship.
Sufficient.
Yes. On
Despite
9/8/2026, the
this,
notice was sufficient.
Sufficient. Nobody has appeared. And yes.
78. Taken up for order.
Yes.
Nice.
What is the sentence?
20 years.
Yes.
20 years. October, February, and 20. Is that girl sending that young girl? Give it to all the stuff. We see. All the yes.
78. Please. So for 3 years only. And admitted and the custody near about 1 and 2 months.
Interim application.
Custody certificate is not received.
Custody reflected in the judgment also.
No, interim bail was granted on 29/7/26.
Item 70.
78, my lordship.
78?
78. It is not
20.
Only admitted on
admitted
on 19/7/2026, and the judgment running page 7.
Case of
Case
9/4, my lordship.
392. Only 3 years punishment and 1 and 2 months custody.
1 day. So, considering the submission made by the parties, the ground taken in the interim application. Then we request in the interim application with the clock. Yes. 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 Service is complete?
Yes, my lordship.
Huh?
In 78, my lordship, notice has been served.
Sure.
Yes.
Pursuant to the order dated 29/7/2026, although notice has already been served.
No, 78 is not required.
You say service is complete?
The lordship is directed of the 78 item.
Where is the order? Let us see.
Yes,
On
my
the- like 29/7/2026.
Where is the order? Where is the order?
my lordship.
Delay condemned and admitted. That's all.
Only condemned.
Where is the order? There is no order. I said. Custody certificate.
I number 1 triple 5. State.
There is no order. Why are you making so? Call for the custody certificate and all.
Custody is very checked.
Jail conduct and all. Yes, next.
79.
79, my lordship, kindly have a glance to the last order.
Yes.
This one is SC state.
Yes.
Not about the SC state, my lordship. SC state, usually in the present case.
But convicted under 201.
201 only.
Only
Then the
201 5 years are right.
Problem is the type of assistance I'm getting this happening.
Yes, but my lordship.
See, that time you should point out wrong orders are being passed.
Yeah, see, my lordship, that's why I just.
Para 94 of the judgment, Lord Secretary.
Yes.
Para 94 of judgment.
94 testing. Yes. Convicted.
Page number 81, 80 and 81.
Running page 81, para
80.
94 of the judgment.
Yes.
I am for Amresh Raut.
94. Accused Rakesh Swai, Nando, is found guilty of offense.
Rakesh was convicted under some 302 201.
Accused Amresh Raut.
Amresh
found
Raut
guilty.
convicted under some 201. And right, allegations 96, para 96.
No, this is the appeal by Amresh.
Yes, yes.
In page number 80, para 93, it was also written that SC state.
96 allegations,
At the
para
outset,
96.
Outset, Mr. Pradhan, Lieutenant Counsel appearing for the appellant submits that there is an error script in the order dated 3/8/2026 in para 5. Para 5. In fact, the present appeal, the appellant has been convicted for offense under section 201 IPC and sentenced to undergo array for
5 years.
5 years.
Array for 5 years. 5 years. However, in para 5 of the order dated 3/8/2026, inadvertently notice has been issued to the informant, public, the victim. Victims taking the offense to be one of the SCT pure. The order dated 3/8/2026 is accordingly corrected by replacing the following paragraph in the front. The appellant has been convicted for offense under section 301 and sentenced to undergo suspension. Yes.
Here, Millard.
Yes. What is the period
When
after?
trial court has committed an error in
No, what is
convicting
the
the
period?
present
Let us see
appellant.
the period.
Well, at custody period, Millard, during
11
trial, I was 15 days for bail.
15 days.
15 days was in custody. From 11/4/2021 to 26/4/2021.
And thereafter, after the judgment.
Yes, after judgment. But
And
illegally, trial court has convicted me in place of Shakti Sakhar Swai.
Let us see.
That you will find from the evidence of PW 21, para 9.
PW
21, para 9.
Amresh Rao, na? Yes. Amresh Rao.
Para 29, PW 21.
PW 21.
Yes.
Yes. Show me. Para?
Para 9 of the chief.
Yes. On that day, I verified the GT footage.
On the same day, my lord.
She was right from source from the found that on between one Rakesh Swami Amresh Raut.
Yes.
Oh, I'm too checking the intent found that it was Amresh Raut was only need to do or to and left taking that this one. They stayed in
Shakti Sekhar Swami assisted him.
for that very found that so the charges was found the dead body the schedule and it from another Shakti. Oh, that day you left.
Shakti Sekhar Swami carry kala monare conviction gala.
But my lordship, TCR is not with me. But
Yes, see, it is there.
yes, my lordship. Yes, I have
See,
seen.
both the principal accused Rakesh and this appellant checked into the OYO hotel, and the same day he left.
Few minutes after I left.
He left. Next day, the dead body was found, and it was found that one Shakti Sekhar Swami was helping the principal accused Rakesh to dispose of the dead body. So 301, if at all is made out, it is against Shakti, not against Amresh.
Se acquittal hai yech.
But I have to
Who is this PW 21?
Are you?
But I have to
At 27 evidence I tell us.
No.
No. Section 27 LRC can you see exhibit P17.
P17.
Yes. Disclosure statement.
Yes.
Exhibit P17. Shakti Sekhar Swami is there in assisting transporting the dead body.
3 persons are there. Out of them, 2 persons.
No. He was there in the preceding night, and he left. Thereafter, the murder has taken place, and he has been charged on 301 only, not 302, 34, anything of that sort.
I have to check my.
You check it. If you want to check the other thing, you check it. I'll list it on second.
Yes, ma'am.
He is entitled to bail. If this is the nature of evidence, then what to do? PW 21 and exhibit 17.
And exhibit P17. Disclosure statement has been admitted.
These two things is enough for the for him to come out. Shakti has been put to trial.
Acquitted.
Then
Means acquitted.
Confused ହେଇଯାଇଛନ୍ତି trial court confused ହେଇଯାଇଛନ୍ତି
maybe.
ଶକ୍ତି ଜାଗାରେ acquittal ଦେଇଛନ୍ତି.
Take it up. Yes. That is on. I said on second, na?
Yes, second.
Second September. Yes. 80. But it is partly heard. There is a that will consider it for the 9 to 10 evidence. Yes. 80. Item 80.
My lord, I am in person. That
It's not admitted, my lordship. It's a 3-year NDPS case, my lordship, 15B. 3 years of
Stamp
conviction,
reported.
50,000 rupees.
delay condemnation. 107 days.
140 days.
140 days.
140 days.
Condone. That week. And then what is the offense? Offense is NDPS. Okay. Yes, next.
81.
My lord, fine 50,000.
First of all, are you appearing in person?
Yes, ma'am.
In person?
Yes.
You are the convict?
Yes. My name is Keshish.
And from 2025, my lordship. order.
I am also practicing advocate in this High Court also. So kindly fine me.
No, fine, I'll stay, no problem. But
fine.
are you are the convict?
Yes, ma'am. There is some, before I was a journalist and written some news against the police. The police has falsely investigated. There is no material manner. I have also argued in the lower court. But Law and Trial Court has said.
Are you on bail?
Yes.
Are you on bail?
Yes, my lord. Law and Trial Court says, I have not accused any person. Kindly excuse me. Only 3 years will give it. What shall I do? The judgment of the
the realization of fine stay.
previous film and continue.
Next.
Yes.
81.
May I please your lordship, madam, 6, so 20 years back. madam.
Notice. Yes.
82.
82, your lordship.
And 70 days delay is also there, 81.
Delay करना ये सारे 37 days is 82. Delay करना. Also is there here.
376, sir.
376,
10 years of
10 years and 10,000 rupees in default 6 months.
Yes. Next.
83.
83 will not division bench.
I just confirm. 17. 17 days. Also in there.
Nothing decided release on this court. Will issue before division by. Yes. Next.
84.
84 may be permitted to
Going for a passover.
76.
item 84 may be permitted to appear through VC method.
Just 2003.
Yes.
Praying for a passover, lordship, may kindly be taken after lunch.
Sorry.
Kindly be taken after lunch, lordship.
No, I have admitted. I mean, you notice also. Yes.
85.
Mobilized.
Delay of 7 days.
7 days delay करना. Admit. Call for the record. What is the offense?
Offense, my lord, convicted 323 by 34 of IPC. 1,005 if not paid 1 month for SI. Your lordship call for the LCR.
For the here. Shall I allow it? PO.
Yes.
I will first allow the appeal itself partly. Granting PO. What do you say, madam?
No, so far as the
323 sentence
Yes.
and only fined.
only fine.
Only
So far as
fine.
the accused number 2 is concerned, he has served the more than 1 month. Initially, my lord. And so far the Rajat Kumar Rath is concerned, appellant number 1.
Instruction I have received in.
That is there, my lord, your lordship, on the page 9.
It's paid or not?
Huh?
I will take instruction whether the fine amount is paid or not.
No, he says that grant me PO and finish it up. I'll grant PO and finish it up. The appeal will be disposed of.
Yes.
The appeal disposed of. Yes.
Obliged.
86
Yes.
Item 86 was hard when you lordship was last Friday, madam.
86.
That conjugal case, madam, they have filed the
assessment proceeding, my lord, assessment proceeding. That
Same.
is interfered with. You also dispose of one matter in 21. I think
Same way.
21. But here is first time. In that matter, we have approached once before this on all court and
It's all right, but
what issue is the same? It's a same assessment. You also dispose of
but
this.
in that case, you came first time, second, first,
Repetition.
and maintainability
Remanded
question.
back.
But here it's straight
Here
away.
first time we have.
Here, madam, the consumer forum has held that it is a unfair trade practice.
Not
And
correct.
basing on that, my lord,
I am not going to do all the merits. I'll simply say the file appeal and appeal court will decide whatever. See?
21.
Yes.
That condone to
Yes,
the
yes.
direct-
On merit, it has to be decided.
Yes.
Yes.
and your lordship is granting interim protection for
No, we are not going to discount power supply.
What interim protection?
Well, because they are now trying to disconnect.
No,
the
we are not
electricity
going to
connection.
discount power supply.
Until the appeal is filed, you will. Yes. This will they do. Yes.
That certified copy be returned. Right?
Yes, certificate copy, same one. Yes.
87.
87 is that matter, voluminous matter. It may be taken up after lunch. It will take some time.
87.
Is that matter the sex scandal matter?
No.
Is my lord is directed to provide soft copy.
What was the last order?
Last order was to file a compilation.
There are more. You have prepared the compilation.
Yes, ma'am.
Have you given the compilation? Give a compilation.
I've given a compilation to the CBI.
And the informant counseling also. Compilation.
It's again a paper book.
Give me compilation.
I'll give a compilation to it. Let it be taken up after lunch.
Mr. Naik, have you got the convenient compilation?
Yes, your lordships. But after lunch, your lordship have some difficulty. Let it be taken some other day.
My lord,
Today only he gave
if it will be urgent, my lord, listed after a decade.
No, Lordship may fix a date.
Give it.
Why after a decade?
18th, 11th or 18th लिख दो. Either 11th or 18th. ठीक है? Either 11th or 18th. C and E. Yes.
18th, Your Lordships?
18th. Yes. Yes. What do you say? Something, my lordship?
Mr. Pradhan's name is reflected in this case. After he laid for evidence about we are unable to trace out the file actually.
Where?
87 item. And we do not know about the facts of this case.
You are appearing or not?
Yes,
Somebody else is
on
appearing.
behalf of Mr. Pradhan, I am appearing.
But somebody else, you are appearing for the petitioner.
No, I am for the petitioner.
He's for the petition.
You are for?
I don't know the facts of this case actually.
So all the parties are appearing. Petitioner is appearing.
I will help him.
You help him. Help him out. Yes, help him. Yes. Give a paperwork at least.
I have also not received my lord.
Give paperwork to him. One copy, give it to him so that he can.
I was directed to provide me through TCR, my lord. Soft copy. I will
Give him so that he will also read. Yes.
90.
80. 90.
So the wife, main accused has already been died and the case has been abated. Your lordship judgment is there. And your lordship can see, case has been abated in respect of municipal accused. That is the copy of the London court below. And your lordship judgment is there.
Who judgment are put into?
A court.
Yes.
Judgment are there, CRLMC already.
What are you seeking? Let us understand what is this matter is about.
Madam, this is a case which has been initiated.
What are you seeking here?
For quashing of the entire proceeding, madam. I am the wife. Present.
Your husband has died. Your husband died and abated.
Abated.
Yes.
Case is under section 13 to 13(1)(e) along with 109 of IPC. And during course of.
So after your husband has died during trial and the trial is abated. Why your husband? So you are saying that
because
case cannot go on against me. That's what you are saying.
Proceedings can go on. Proceedings can continue against the wife.
Yes.
Who judgment?
Give him here.
His lordship judgment. They do sanction.
No, this is in a different line altogether.
That is in case of a vigilant case, husband died, wife is the not a government employee, and the entire case has been closed.
Who case?
No. This is not the case.
May I know the petitioner's name, my lord?
This is something different.
Can I? Wrong.
This is regarding this. The husband died. Nothing of that sort in this case. If my memory serves me rightly.
May I know the name of the party?
That is your lordship judgment. I'm just handing out that I'm referring that judgment and also.
Show me where the husband has died.
My lord, that is the document I have produced before lordship. Certified copy of the London court.
Judgment who judgment is the name
Factored into
party name my lord, may I know the name of the party? Yes.
E. Sonalata.
E. Sonalata husband is still alive. In that case, wife was not an assessee. The wife claimed that.
There the abatement is abatement under 107.
107?
What abatement?
In the
it's not a death abatement.
In the present case, my lord.
Why are you trying to see? There are abatement. Once somebody dies, there is an abatement. And this abatement is different.
My lord. To that extent, my lord. No, exactly.
How are you covered by this judgment?
My lord. I am
not your case is not even reaching near the judge. Facts of that case.
My lord, I am pressing before lordship.
The fact of that case and this case is also
completely different. Is completely different.
Different, my lord. I am placing before lordship. Two sentences.
First of all, you take back your statement that this you are not.
No. I am.
Merely because abatement, what is there? This abatement and that abatement is
completely different.
That is wrongly I have handed that. That judgment is with me. Your lordship judgment is there. I am placing before your lordship few sentences, your lordship will appreciate. Case of
You simply tell me, show me any judgment where the husband facing trial along with you under 13(1)(b) or whatever, along with 109. If the husband dies during the trial, trial averts, the trial against the wife cannot go on. Show me the judgment.
Fine. To that extent, I will produce. One sentence, my lord, I am submitting to the lordship. It's a case of abatement. Whom I have abated? My husband. That as per their allegation. There is no documentary evidence.
That is a different thing. On merits, if you want to argue, that's a different thing. The first thing which you have said, that my husband has died, the trial abated, so therefore this trial can't go. And you relying upon judgment which has nothing to do with this.
That is a case of whom? Wrongly, my lord.
Except in what abatement is written.
Abatement.
That abatement is abatement to 107 abatement.
It's a 109.
Abating the husband to commit the crime.
Crime, my lord. In the present case is a 109. At 13(1)(e) and 13(2)(d). My lord, that is the case. I am E. My lord, I am placing before lordship. This is a case where the husband has been implicated in the instant case at the behest of the vigilance department. During course of investigation, they have stated so that.
Where is the charge sheet?
My lord, charge sheet. And producing before lordship. Charge sheet, my lord. That's it. Now.
Have you filed the charge sheet?
No, charge sheet I'm filing.
That's the only document I need to know.
I'll file the charge sheet along with that.
After me for some time, seeks adjournment to file the charge sheet. Is there any interim order? Is there any
interim order is there?
I'll vacate the interim order. What is this? Without filing charge sheet, you have taken a stay.
No, cognizance
and
order.
showing a judgment which has nothing to do with this case.
No, cognizance order and other things, my lord, I have filed. So, sorry, my lord, I have not filed the charge sheet. I have failed considered.
You are challenging the cognizance
order.
And charge sheet is not there. Okay, she seeks time to file the copy of charge sheet within a week, subject to paying a cost of ₹1,000 to the Bar Association. One with time getting filed to the charge sheet and the document. Is the matter on 16th of September.
Well, May and can it be 19?
Huh?
Can it be 19?
Okay.
Because, that week I will not be available.
19th?
9th.
23rd.
9th September, I have got that charge sheet copy. I will file it.
Yes. Pay 1,000 cost to the bar. Yes.
Interim order में time.
91.
Yes.
91.
Nobody there. Offense?
91 and 92 is same. Arising out of civil dispute. Half of the.
Yes. Seeking quashing of the proceeding.
294, 507, 506, 34.
12/8/21. 12/8/21. Yes.
It's for the opposite one, informative.
Who is for the?
I am in the second case for the informant.
Second case means which one?
3881.
92.
92.
You are for petitioner.
No, I am for the opposite party number 2, informant.
And in the first item, 91, you are the opposite party.
Opposite party. Petitioner counsels the law.
Who is this? I'll just pass over then, Mr. Siddheswarman. Both 91, 92 pass over. Nobody comes, then I'll pass.
The case where civil suit is pending. Administratively, they have filed the civil suit. The petitioner here. Issuance of NBW, they have not appeared in the case. After issuance of NBW, they have approached this honorable court and the court will stay 8 years till today.
I'll dispose it up today itself. I'll dispose it up today.
They have stalled the civil suit and all this.
91, 92 both.
Yes.
93.
93.
If I may please, Your Lordship, my lord.
Deputy
In the last
Total
question, Your Lordship had heard the matter.
Total matter.
103.
Yes.
My lord, on the last occasion, Your Lordships had heard the matter. This is pertaining to that the original I am the intermediary. This check was issued by one other party. That is the cause of action, and I have been made arraigned as a accused, and cognizance has been taken.
Yes, who is appearing?
My lords, I am appearing for the complainant opposite party, my lords. Yes, lords.
Yes. Yes.
My lords, I went to the brief and I have examined. As such, my lords, as it revealed from the case, my lords, no liability is against the petitioner. It is apparent, my lords. So, without recording my concession, my lords, may.
But a very fair submission, my lord.
And party. And party. Yes. Presence of Edu? Yes.
94.
Grateful.
Please, Your Lordship. I am appearing for the petitioner, my lords. My lord, the petitioner has approached this honorable court for quashing of the cognizance order, which is in Annexure 3, page 18, my lords.
Parties are directed to appear. Parties are directed to appear.
Yes, Your Lordship. So they are on VC.
Yes.
Both are appearing.
What is the dispute?
Dispute is completely civil and commercial in nature. 409 was initially the FIR was lodged under section 409. Thereafter, after filing of the charge sheet, the cognizance were taken under section 409, 467, 468, and 471 IPC. But the entire dispute is between the employer and the employee. The alleged amount of 28,608 that has been recovered from the petitioner.
Who is for the
Opposite party number 2.
I'm Jitendra.
My name is.
What do you say? Is there any chance of settlement?
Yes, yes. Expected.
I have filed an affidavit that I have.
Affidavit is on record, my lords.
Then I'll dispose it up.
Your lordship.
Like we can.
Yes. The informant is Jitendra. Jagan is the accused.
Yes, Your Lordship.
The petitioner has filed the passing of the. Where is the order taking cognizance?
Your Lordship, the order was taken on 13 to 2023.
13 to 2023. Passed by
Learned JMFC Cog Aska.
In GR case number 657 of 2022. Whereby cognizance of offense punishable under section 409, 467, 468, 471 IPC has been taken against the petitioner. Notice was issued to the opposite party by the order dated. Right. Notice was issued to the opposite party. And the last date of hearing, that is on 29/7/2026, this court directed the petitioner and opposite party to appear in person through video conferencing mode. Today, when opposite party number 2, Jitendra Yajaria, and the petitioner, Mr. Jagan Kumar, has appeared in VC mode. The counsels appearing for both the respective parties have identified them. They've also filed self-registration copies of their Aadhaar card to establish their identity. Both the counsels appearing for the parties as well as the parties appearing in person conjointly submits that they have entered into a settlement, and they've also filed entered into settlement. The appellant, the opposite party number 2, has also filed an affidavit dated 19/3/2026 inter alia stating that para 4, 5 and 6. Para 4, 5 and 6. The petitioner has filed the FIR. The opposite party has filed the FIR against the petitioner, being ASCA PS case number 296 of 2022. So the parties have already settled the dispute and filed affidavit to that effect, and both the parties have appeared in person, and reiterating their stand that they have already settled the dispute to
I'm deeply grateful, Your Worship.
Your Worship, affidavit date of 1905.
1905. Yes, I'll verify it. Yes.
Four, you're fixed for 2 p.m. minutes. Okay. Item 24, your Lordship's flip list, which is fixed at 2 p.m.
That was at first hour I was mentioned that I'll take some of the day.
Minutes.
Didn't know. I have conveyed to my friend as your Lordship proposes.
3 minutes, there is an interim arrangement. With the last,
that will go on.
the Lordships are fixing it to next week. Which I have 3 minutes.
Not next week, we'll see. I'll give a date. Next week, lot of matters.
Well, the Lordships had heard it in part, so.
But that's right, but what can I do? You tell me. How many matters one can hear every day?
Inconvenient day.
Matter is listed, I expect that it should be heard. But once it is judged, means it's very difficult to adjust the board.
No, only it was there from the state
Anyway,
of
we
Ireland.
will see. Instead of wasting time, we'll see. Yes, yes.
So, interim arrangement next.
So item 5.
My Lord.
Yes.
The POCSO 20 years. POCSO offenses is there.
Notice.
Notice.
Third.
No. Objection being called the notice as notice. Admission. Delay can condone है adjourn to next week. That was only.
It has not been admitted here.
Not been admitted.
Okay. Admit. All for petition. Yes, next.
Delay may be condoned or not.
Delay condoned. Yes.
Item 20.
Obliged.
In this case, my lord, I have challenged the order dated.
Yes.
Challenge the order dated 2/6/2026 passed by the Honorable State Consumer Dispute Redressal Kotak, my lord. My lord, as per Section 41 as per statute, Section 41 of Consumer Protection Act, appeal admitted only after deposit of 50%. After that, the petitioner deposited 50%. 50% deposited, and my case is admitted. Again, the Lord and Honorable Consumer Forum again directed to deposit another 50%.
Where is that order?
Order page 12.
No, where is the first order?
Well, this is the first order, 2/6/2026.
You say 50%.
The statutory deposited 50%. Hela pore admit hobo. 90,000 deposited. Again directed to deposit another 50%.
Intervene directly the operation of
Yes, ma'am.
the further the appellant is directly to the preparation of the all amount before the commission, we can keep up to it. Yes, so
Similar order also.
The court only says that 50%.
50%. Statutory deposit 50%. That is my.
You have deposited
50%.
statutory deposit at 50% when?
50% deposited, my lord. Is an DD deposited on 15/7/2025.
15/7 after this order.
After this order. Statutory deposited 50% hela pore jai admit hobo.
Yes, it is admitted.
Yes. In this order, again directed to 50% deposited.
It is not again. You have deposited after 2/6/2026. Then you, in July you deposited.
So at the time of filing the appeal, first deposited 50%, then my appeal.
Where is that? You say me. That is what is order is also indicating of that too.
Not indicated, but statutory deposited 50%. Then my appeal will consider or admit.
The same thing the court says. The commission says. What else? Commission only says that deposit 50%.
My already deposited 50%.
You may interpret whatever. That is what the order is.
Just read the order. Impugn order.
Yes, my lord.
Now you have deposited, you complied the.
Deposit 50%.
Then it will be admitted. What is the big deal about it? Why have you challenged this order? I don't understand. Read the order. First.
Yes, my lord.
The order dated with the date 2/6/2026.
Yes, my lord.
It says that as an interim measure, we direct the operation of so and so at the further order. The appellant is directed to deposit 50% of the awarded amount before the commission within a period of 2 weeks from the date of receipt of this order. You deposited when?
Deposited, my lord, 15/7/2025.
Done. How are you aggrieved now?
My lord, first I deposited 50%. 15/7/2025.
I am asking whether before this order,
yes, before.
Have you deposited anything? That's what I am asking. When you deposited?
Deposited 15/7/2025.
25.
25. Yes, my lord.
And after this order?
After this order, my lord. The digital amount, 50%, 100% coverage. I'm case karo.
Show me the amount.
Amount, my lord.
Where is the order?
My lord, page 26.
Page
26.
Yes.
Page 26.
Directed to refund the down payment of 6%.
First, we have the District Consumer Dispute Redress Commission of Malkanagiri. 170 plus 13,900.
120 plus and plus
180,000.
It is rejected by the order dated 2/6/2026, whereby the State Consumer Forum, while it has been admitted or not?
Yes, madam.
While admitting the appeal, as directed by the order dated 2/6/2026 to deposit 50% of the awarded amount, and subject to deposit of the say 50%, the operation of the impugned order dated 11/6/2025 passed in CC number 4 of 2024 by the District Court as it state. The Learning Council for the Business Public that for the purpose of admission to the appeal, the statutory deposit of 50% was done by the petitioner on 15/7/2025. Thereafter, the only appeal was accepted towards the court. Therefore, direction by the trial court to direction of the State Commission to pay. Direction by the State Commission by the impugned order to pay 50% would be tantamount to compliance up to the total compliance of the order up to 50%. Therefore, we agreed and hence approach this court. In view of the aforementioned, issue notice to the opposite party number 2 to 4. By tomorrow you file it. Listing it on because it has to be allowed on 16th of September. 16th September.
As an interim.
Till further order and till next date of hearing, we will be not so is state. Yes.
Hon'Ble.
Subject to file the petitioner filing the requisites. If you don't file requisite, no stay.
Tomorrow.
43.
Yes.
Custody near about 11 years, man. 11 years in custody.
My lordship, kindly have a glance to the.
Sorry?
My lordship, 6 POCSO is there.
Okay. Notice are gone.
Notice, my lordship, here the notice should be go to the informant Nittabaral coordinator of Open Shelter. Vishwajeevan Seva Sangha. 376D is there.
Issued through the IOC. Custody certificate is conducted we also. Yes.
In the meantime, custody certificate.
Yes, I've done it. I've done it already. Yes.
This one refers to victim and
You don't listen the order. Whatever you are saying, I have already done. Carefully listen. Yes.
91.
Yes, 91. Take it out. Fine. Yes, 91. Yes. You are for the first item. Let us see. First item.
I am for the informant.
You are for the respondent, opposite party, isn't it?
Right.
What is he challenging, petitioner?
The order of holiness has been challenged, madam. Your lordship has seen last order.
Bar after this is the request.
It is 1/11/2020.
Yes. Yes, except notice.
The order passed in IA numbers.
That the parties are related with sister and brother. And it submitted that the sisters are before this court against the brother, namely the informant who lodged the FIR with the allegation continuing so on, which is consequent of this. Yes, what are the allegations in the FIR?
Civil suit is pending, my lord, filed by the same petitioners. They have suppressed the fact that the partition was done and the deed of settlement has been executed. Now, basing on that, they have shown their part of land, and this informant has also, who is a brother of the petitioner, he has also sold the.
Yes.
That is the.
Then
suit is pending, my lord.
The FIR has to go there.
FIR has to go. But suit is pending, which can be 2018 that's pending between the same.
See, the FIR is registered by you only.
Well,
in this. But you are not a party.
Then I was added as a party owner.
By which order?
1/11/2022.
1/11/2022. Where is the order? You have not been implemented. Where is the order?
Sir, say 1/11/20, para 3.
Para 3.
Notice we issued to the informant by registered post, which actually return at an early date. And
Yes, sir. Pursuant to the notice you have appeared, you concede that civil suit is pending, so therefore.
Well, no, they have averred it. They have stated in para.
Are you conceding because you are the informant? If you have no problem, I will quash it. As simple as that. Why should you get into all the things? What about the second matter?
Second matter, my lord.
Same. You are the informant.
I am the opposite party number 2. I am the informant.
Yes, that's what I say.
I am the informant. In this case,
so you also have the same thing. Then the prayer made by the petitioner, those who are the accused in your FIR, you have no problem. Since civil suits are pending, your dispute will be sorted out there in civil suit. So therefore, the FIR has to go.
FIR has to go. This means they have not cooperating with the.
I am not on that. The FIR has to go or not, you tell me. You can't have both.
If I have filed a complaint case, man.
A complaint case has to go. I'll quash the complaint case. In first case, this is FIR. In second case, it is complaint.
Because they are not appearing, they have issued with the NBW. Challenging the NBW order, they have approached your lordship.
Second one, I pass the order. It is not regarding the quashing of the complaint. It is regarding the NBW.
NBW, my lord. Your lordship may turn to page 39.
No, you are wrong. In 92, item 92.
Item 92.
They are challenging cognizance order.
Cognizance also challenging the order dated 16th.
Why are you going here and there? Why are you not answering the?
Yes, I am sorry, my lord.
They are challenging cognizance order. Do you have objection?
No, I don't have any objection.
Then I'll allow it. I'll quash the complaint. What is this? I don't understand. I'll pass the order. Because the petitioner is not here. He is not appearing. In his absence, both of you, being the complainant, concede to his prayer. Therefore, I am asking.
I am brought you to your lordship's notice that 16.7 order challenging the cognizance order. So also NBW.
That is a different story. If the complaint goes, where is the question of NBW order? So on your concedement, I am passing the order. Okay, 91, 92, both the orders. I'll record.
May I pray one thing?
Yes.
Can your lordship direct the civil suit may be expedite?
In the 482, I will give a direction to the suit court. While saying something, at least think over.
Because I am suffering.
I am exercising 482 power. I will direct the suit court to expedite this suit.
In fact, my lord, they are not cooperating in that suit.
Whatever, I don't know. That is your problem. That is your problem. Yes. 95. Yes, 95. Yes, sir.
The order of conveyance taken by the court will SCG special cutoff in 2 ACC case number 162 of 2019, wherein under
Yes, yes.
offense under
276B income tax. Yes.
This was covered by my lord's judgment that was reported in C Metallic and that Kashmir International Private Limited.
Which is the principal judgment?
The last one is the 2622.
No, it is regarding delayed filing or delayed filing?
Delayed depositing the
Yes.
TDS amount.
And the interest amount you have already paid.
Deposited.
Deposited. Who is appearing?
I am appearing for the
Yes. Covered by this.
if you can solve a copy of me, I will examine that one. I didn't have the reference.
They are directly covered by this judgment. I say that if delayed payment, if you have accepted the interest part, where is the question of prosecution? You can't have both.
In other words, it is a compoundable one. That is also
Compoundable. In fact, they have to go to the court and move application.
That is it.
Then I have corrected that order.
In that observation it can be done.
You can move application before the.
That is what required. That is what required under law.
No. In because there is a procedure of compounding. There the compounding penalty will be paid to you.
I have deferred, they were rejected.
Show me that order. Show me that order. Have you filed this order here? Have you filed this order?
After not doing the interest. Paragraph 7. Accordingly, the application filed for compounding the offense for the assessment year 13-14 is hereby rejected.
When have you moved this application? While this petition was pending here?
Oh, God.
When have you moved this application?
Yes.
When have you moved application for compounding?
No, during the before that is 14/3/2023.
You bring this and record and give a copy to me.
I will file a mail.
Bring this in record. Entry want to continue. Let counsel for the petitioner to file the documents. Some additional documents. And copy of the petition is also not give a copy. Yes. 96. Sorry. We sit on 21st of September. Yes. 21st September.
Let's say kind for us. I may be sorry, excuse, I was held up in a court. Item 91, 92. My power is there after consent. So you'll also record that disposed of. I just heard from that. You'll also
It's already over.
My name is because I have entered my appearance, so let's direct for.
You are for petitioner?
Mar.
Okay, petitioner.
Published.
Yes, they have considered your petition. Both of them have considered your petition, so therefore, on that basis, I will allow.
Because I have filed the power, let's go direct for 91 and 90.
Yes, 96.
I am filing the all the death chart and all the decisions.
Yes.
That case where the
My lord, for if I may please the lordship, my lord. My lord, Mr. Roy was to assist your lordships. My lord, I am not properly prepared. I will need 1 week's time. I'll have a copy of his written notes and I'll assist your lordship if your lordships grant me any day on your lordships.
That day I heard it.
Your lordship has heard my knowledge.
And you say that
my lord,
that day you were ready.
My lord, after going through the brief properly, my lord, I believed that it needs more
These
preparation.
matters are unnecessary pending. Small matters. In fact, don't go by the volume of the issue is very small.
I bow down, your lordship. Your lordship may kindly accommodate me. My lord, Mr. Roy was to assist your lordships.
Written note of submission. 7th.
I have given those decisions with several decisions. One, your lordship has seen that 482 and that no inducement arising out of a contract.
Right.
Then the second I have given that there is no pleading anywhere in the complaint petition or in the FIR.
It looks like an arm twisting method for.
My lord, I'll try and satisfy your lordship. Let it come on 7th and address your lordships on merit.
That they have.
I'll try and satisfy your lordship.
Due is there 38 lakhs or something.
32 lakhs odd.
Not against me, against my contractor.
I'll try and assist your lordships.
You have to
My lord, I'll try and assist your lordship.
resort to recovery proceeding.
My lord, I'll try and assist my lordships. Great.
Written note of submission filed by Mr. Mohan.
Treat it as part of.
I will hear you only. I have heard.
Yes, your lordships.
It is for your hearing.
Grateful, my lord.
The lordship may kindly treat it part.
Yes, parted.
Interim order to continue.
Interim order to continue.
My lord, 7. It will come.
8.
8. Great.
97. Yes.
Please, madam. As there are 3 petitioners before your lordship, the husband and the parents-in-law. The present petition has been filed charging the order of cognizance taken up under section 498A, 304B, 306, 406, 34 IPC.
Notice was issued.
Yes, my lord. The opposite parties have appeared.
Find my affidavit, my lord.
My lord, the parties have mutually entered into a settlement, my lord.
Settlement.
Yes, my lord.
Offense is? 498A.
498.
Yes, ma'am. 304B.
304B,
304B is also there.
Yes, ma'am.
306, 406.
Then how will you do it? What is the state?
The investigation revealed that
It is suicidal in nature. At annexure 2, my lords.
Even 306 charge has been filed.
Yes, my lords. Cognizance has been taken.
Cognizance taken under which provision?
Under the same provisions.
Where is the cognizance order?
Annexure 1, my lords, page 9.
under section 498A, 306, 304B.
Can it be done? 304B and 306?
Yes, my lords.
Show me.
My lords, with regard to the, my lords, if my lords may first see annexure 2, page 29.
Yes.
That is, which shows that the death of the deceased has due to poison consumption. And
That's right, but you show me some judgment where I can invoke the jurisdiction 306, 304 can also be passed on the basis of settlement. Show me some judgment.
I'm passing on the order of a coordinate bench, my lords. Recently, that has been passed.
They are not asking only on the basis of settlement.
On merits also.
Documents show me not that the death is suicide. And there
No, okay, it's 306. 306 can also
there is no material belongs to show abatement by me.
Then on merit I will have to hear. If not on settlement.
In any event, judgment also, that was also a dowry judgment.
What was the offenses here?
Same offenses.
80, 85, 1031.
This is the corresponding of
Yes, do you have any?
I have to verify.
Huh?
if I
Have you? Do you have any objection? Because you are the state, you are prosecuting. You have to say, shall I write your concession?
No.
Then you must tell yes or no, whatever. No means what? I will not pass the order, or what? No means what?
Yes, I am having objection.
See this judgment directly covered by judgment. The only stumbling block is because 306 is there.
Yes, ma'am.
On merit, I am not going. On merit also, he says that merit can also it requires. But instead of going to merit, if the complainant says that I don't want to press, on that basis also it can be disposed of.
Yes.
If you say no on settlement, it can't be done. I'll enter into merit. I'll decide the case.
My submission again there is, even if your lordship not enters into merit, but on the basis of the settlement. Yes, what will happen if your lordship?
I know, Gyan Singh and all
Only
these
I do not know. I do not know evidence is going to be
he's
there.
not supporting you. Suppose you will put to trial. What will happen?
I do not know witnesses.
The complainant himself will be the prime witness of yours.
Yes.
He's not supporting you. So putting them to trial is a exercise.
What's time waste?
So therefore read it and tell me.
No fruitful result will yield.
Give it.
I have given him a
Yes, yes, I am having.
And I'll list it on, see, since this is a small matter, I'll list it on third.
Yes, ma'am.
Read it. No adjournment, I must tell you. Read Gyan Singh also. We say that if there is a blink chance of securing conviction, and it can be quashed.
Supreme Court 709.
So many judgments are there. The complainant is the sole witness. He must be father or mother. No, father.
Father.
If you will not support to the prosecution, what evidence is there?
It's interim orders to continue.
Entry mode continue third. Yes.
98.
Despite service of notice opposite party number 2 unentered appearance. What is the offense? But what is he asking for? Is the notice of party convenience order. The convenience order is non-appeals for the petitioner, and even the service for notice under form number 2 is not sufficient. This is the step scheduled to October plans of
99.
Pray for Passover.
At this stage, what Passover, madam? Let us see. What is this case?
This is a case like this, madam.
You are appearing for the opposite party.
Petitioner. I am opposite party.
Yes.
Madam, here is the case. Initially, at their instance, a case was registered, which was registered as Golonthra PS case number 307 of 2025. But from the side of the opposite party number 2, lost an information which was registered as 309 of 2023. They have annexed it as annexure 1 and 2. Where charge sheet has been submitted for offences 143.
Why there are two fire? There are two.
No, for a particular incident, they lost the information. So, and in retaliation to that, we also lost that information. From our side,
Annexure 2 is your FIR.
My affair.
Annexure 1 is their FIR, which is subject matter of this petition. Yes.
After that, next day, another affair was lost by opposite party number 2, where a higher offence was added, 395. And that case, that affair was registered as PS case number 315. And they have annexed it as annexure 3.
No, annexure 3 is 315.
315. Second FIR lost by opposite party number 2.
Yes.
For the same incident. Incident occurred on 5/7.
Where is the aggravated offense? Nothing is there.
I'm coming to that.
Yes.
But the grounds they have taken, that this comes under double jeopardy. Double jeopardy means when section 300 is that if a person is convicted or acquitted, atrocious acquitted. Not that if two affairs have been lost, whatever it may be, this third affair, the annexure 3, was subjected to investigation and final report was submitted.
Third FIR, you are the informant.
Complainant. Yes, informant. Police case. After that, a protest petition was filed where cognizance has been taken for the offence under 395 and higher offences. But here the law is very clear under section 210 CRPC. But 210 1, 2, 3.
395 now.
Yes. If 395 cognizance has been taken, it cannot be subjected to double jeopardy. Unless trial is held, person is convicted or acquitted.
Exactly. Investigation says what?
Yes.
Jeopardizing.
And that is the ground which they have taken in paragraph 8.
Investigation says what? Double jeopardy, triple jeopardy. Investigation.
That's why I'm saying, my lord, kindly pass off the matter. I have some judgments, my lord. I have not gone through that judgment.
Pass over.
Pass over.
Pass over Arjun.
And let it Arjun, my lord.
You are the counsel. You will argue or somebody else will argue?
My senior.
Acha, senior counsel.
27 plus
20.
This process is being adjourned.
27, 20. Okay.
27.
Okay. In September, first week, my lord. All the
Full-
matters
full.
are fixed in 27, my lord.
Is there any stay order operating?
Yes. They are taking the. When I never oppose.
Prima facie, you don't have a case.
No.
It's
28.
It's only cognizance order.
Oh, my lord,
And you can argue that on the charge stage. Go and argue whether made out or not. You can do it.
The case, my lord, that's why I'm saying, my lord, can you take it, my lord?
28. No. When 28.
28 not possible, my senior will not available.
You will not be having.
Then it will go to 18th.
But it's
17th
the way Bharat see the orders sheet. How many times they have taken time? Last occasion, before that, after getting the stay order in the very first instance in the year 21.
Passover. Passover not possible, then I'm
Passover Bharat.
Is there any chance of settlement? No.
No question of settlement. But here case, they are there in Dragon's draw, so to say. On 28th will be taken up. But his senior is, our senior is not available on 27th, 28th.
27, 28, she says the problem. Again, she will ask for adjournment. Let it be on.
On second minute.
Second,
the last chance.
Second.
Interim order.
That is why you are seeking adjournment. Yes.
No, my lord.
Anyway.
I am praying for Passover, but my senior is
Anyway,
not possible.
till second,
Then I
till
will-
second, no problem. Yes. Item 100.
Interim order.
Intrude.
Yes. On second, but the last chance.
Yes.
But I am for the informant. The check bounce case I have filed since 2014 is stayed.
Mr. Bose is already held up in another matter, which is already fixed 2 p.m.
I have also filed an application for variation of the interim order, vacation of stay since long and last order also. And the check bounce case is already stayed since long.
1 week or after 2
No,
days?
interim order is
Already.
operating.
Already.
You will also record my concession, let the application be allowed because he has come for 311 recall of the witness. You will also fix up a date, let them case allow. Target है जो case tag है वो 2011 ना check.
Show me the.
So kindly see page.
I'll allow, madam.
हाँ allow करते हैं.
Yes.
Page 7, the impugned order.
Instruction from.
What instruction? You are asking something, I am giving you. Yes.
Annexure 7, page.
Everything tomorrow. Please.
No, I'll allow you. Allow the petition. For allowing your petition also you have objection.
He has come up with to give a chance to cross-examine to himself. He will kindly see page 8.
8.
My lord. The impugned order starts from page 7. Page 8. The counsel for the accused petitioner.
How many witnesses is speaking?
He himself wants to be re-examined.
Where is the application 311 application?
311. Again.
Intended to release given by the evidence to clearly
copy evidence affidavit annex 3 page 17 page 17 18 but application is not there. He has not filed the specific application. As it orders appears me Lord
the counsel for the accused
its objection
due to his illness and due to some misunderstanding of the previous counsel, the accused could not attend the court to give his evidence. They fixed and he prayed to give him an opportunity to adduce evidence in his defense. And he further submitted that if the opportunity would be granted, then the accused will be prejudiced so. He has not led evidence at all. Okay, the period the petition's objection.
Page 7 annex 1. You also fix a one date. They both will appear and
closure of evidence from the side of the complainant.
When the Lord Court has rejected a recall petition, that is annexed to page 7.
The record was posted on reducing defense evidence. The accused took time to solve the argument and finally filed out the petition. Rejected by the court because evidence has been closed. Now the accused has the petition himself to use evidence. Oh, his defense evidence was closed.
That is why he didn't come. My lord, checkbox case, in the practice of the accused, they never come to court. They linger the matter. Lordship may allow, and may not record my concession, but Lordship may make objection with regard to delay, maybe up.
Petitioner is an accused in 1 CC case number 1011 of 2024. The trial court rejected his application under section 311 KRPC for reading defense evidence, declining to the defense evidence. 311 rejecting his application, seeking an opportunity to lead the defense evidence. Agreed by the same, the present petition has been filed. This court, by order dated 25/11/2024, issued notice to the opposite party, the complainant, Mr. Mishra, then the counsel entered appearance on behalf of the complainants, opposite party. Complainant, opposite party?
Again.
Two, opposite party. Without entering into the without joining the issues with the petitioner, Mr. Mishra submits that due to the operation of the interim order in this present proceeding, the trial of the 160 case is getting prolongated. Therefore, he submits that the present petition may be allowed, and one opportunity may be afforded to the petitioner accused or to reduce his defense evidence.
Single date.
And at the same time, referring to the provisions of section 143 2 up to NIA, he submits that the complaint of this nature is mandatorily required to be concluded within 6 months. Hence, the accused may be afforded one opportunity to lead the defense evidence, and on the pretext of leading defense evidence, he should not be allowed to prolong the trial. The submission made by Mr. Mishra reserves merit. that the present petition filed by the petitioner accused be allowed. The petitioner accused the afforded the trial court is directed to afford one opportunity to the accused petitioner to lead the defense evidence. To lead defense evidence. Yeah. It made clear that the accused shall not seek unnecessary amendment and he shall conclude his defense evidence as per the opportunity to engage by the trial court. But in any case, since the complaint case is pending since
2014,
the trial court shall do well to see.
By end of November, 3 months.
To see that the entire trial of 1CC case number 1011 of 2014 is concluded maximum within a period of 3 months. Hence,
Great.
this observation, the petition stands allowed. Yes.
Grateful.
101.
Argue on behalf of Mr. Naikman. Earlier, my lord. 3125 lordship passed an order. Direction it comes to obtain the case. 3125.
What is this case?
There are two cases, my lord. Same set of allegation, my lord. There are two cases, my lord. First case is my lord, Hon'Ble PS case number 145 2023. Second one, my lord, 146 2023. I am challenging second case, my lord. 143, my lord. Both the cases cognized taken, my lord. Charged sometimes both the cases.
But if you see Annexure 1,
my lord.
Annexure 1, 146 of 2023.
my lord.
Annexure 2, the case is?
My lord, annexure, my lord. Then annexure, my lord.
Same 146.
No, my lord. 45, my lord. Annexure, my lord. 4. Annexure 4.
Why Annexure? What is Annexure 1? What is Annexure 2? Or charge sheet? Okay. Annexure 4.
4, my lord.
Okay. Annexure 4 is?
First affair, my lord. Hon'Ble PS case number 145. Page 53. But there, my lord, the police, after receiving information regarding these petitioners, my lord, belongs to truck owners association, my lord. They blocked the road, my lord, the main gate, my lord. Demanding that the 16-wheelers vehicle not allowed to loading the mines materials, my lord. Thereafter, the police went there.
Who is the informant in this case?
First case, my lord, police is the informant, my lord. 145. Second case, my lord, OMC manager is the informant. Same allegation, my lord. After receiving reliable information, police went there, lodged the information, and carried the investigation in the evening hour. On the next morning, the OMC manager lodged another affair, my lord. Evening, my lord, taken to consider.
Take out notice to the informant.
They have directed to call for the case diary earlier.
You got it.
Criminal antecedents are there, my lord.
Antecedent ରହିବ, you know, rivalry. But subject matter, my lord, is that, my lord, whether the second case will go or remain, my lord. Since same allegation, another case is pending, my lord, against them, and charge sheet was taken against them.
As many as more than 4 antecedents each of the persons.
And there is no such name in the FIR, and also 161 statement, my lord. How, my lord, the police somebody charge sheet that is asked? Second case, my lord. First case, my lord, we have no objection against the fact.
No, you are seeking quashing of Annexure 4.
4, my lord.
Annexure 4.
My lord.
No,
my lord. My lord, Annexure, my lord, 3. Annexure 3. 3, page 52. Order of cognizance. But first case, cognizance taken 28/7/2020.
8824.
My lord.
It is regarding PS case number 146 about 23. That is Annexure 1.
My lord.
Cognizance is taken
8824.
Yes.
And but the second case, first case, my lord, cognizance taken 28/7/24. My Hon'Ble before let the my lord 145 cases may run, my lord. But a subsequent case cannot run, my lord, as because, my lord, that is, my lord, I am annexed 161 statement.
Okay, take out notice to the informant in the present case. And the notice be served through the IAC staff for Hon'Ble PS. Means the matter on the safety. Entry order to continue.
Entry order
to continue. Yes. October. Yes.
102.
My lord, management has not been made party here.
Take out notice, you take out notice.
Exactly. Petitioner conviction under section 6 so my lord. Custody, my lord.
This for what?
10 years.
For bail.
No, admission.
Not even admitted. Okay. Admit. There is delay.
Delay.
Okay, admit. Also record also, and if notice one of the open session. So yes. Yes.
103.
Hon'Ble.
Window. Instead on the heading of hearing of, I filed your side 10 years conviction under section 21C of the NDPS Act, and he has undergone imprisonment for more than 5 years, 4 months, and he was directed to be released on interim bail for 2 months, I have complied and I filed this.
What about your antecedents?
Antecedent kichhi nahi, no antecedent.
Verify antecedent because it's the NDPS case.
No, notice has not been used. I have to obtain antecedents.
Okay. Custody certificate, jail conduct and antecedent is summoned for from the concerned authority. Please see matter. You have undergone how much you said?
5 years, 4 months, 18 days.
Out of?
10 years.
10 years, 5 months. Then sort it out. Okay.
The IIT for bail, say I consider 2177.
Yes, on that only I am asking for antecedent.
Say.
Okay.
Weekly item 3.
Weekly calendar. Item 3. This is against specific word.
Second, these are good approval to Sangram Rautra as she explained to you.
This is against acquittal.
Yes, yes, sir.
Yes, all for the order of acquittal now. Because in the beginning, the writing order of the judgment of acquittal passed by judgment of acquittal dated far out 97, passed by in criminal appeal report 83/26 of 1997 1995. 1995. IAC Manga Plus has filed a report dated 24/8/2026 in the area informing the court that the sole respondent accused was acquitted in the acquitted by widely has already expired on 22/11/2020.
My lord, item 4, I am in virtual mode, my lord. My lord, I am in virtual mode. Item 4, my lord. Item 4. Item 4, my lord.
Yes.
My lord, item 4. Will it be, I think my lord is rising for the day. So can it be after 1 week? Because there is a bereaved in the family. So I'll be engaged in the Dasara ceremony and all that.
Yes, let it come next week, no problem. And let it remain.
But in this case,
In the meanwhile, my lord, the opposite party may take instructions and also have the objection if any to my.
no, I've got the instruction. The meantime, 2 witnesses examine the trial is in process. And this is a case also, this onlooker already directed that you must face a trial. There's no escape to it. And the wife has gone to
2 witnesses have already been examined.
I'm coming on the point.
Okay, we'll see next.
Well, item 24. Please maybe take it up tomorrow first, because that case has already been heard by my lord.
Today there are many orders which I have to pass.
Okay, sir.
Sorry, too many orders to be dictated. Sorry. One judgment and one 5 orders. Sorry. No, this matter already has been heard. I will dispose of.
In fact, I was requesting my friend, my lordship, to be provided with the breathing gap to dispose of all the detecting the orders.
And now about 50 APs are accumulated to be disposed of, to give dictation. 50 APs. I need little time, to give dictation.
I wish and I pray that God should provide with all the potential patience to dispose of all the matters.
Yes.
It's not there in the cause list. The lordship has appointed me as the
The
application.
name declares 70.
And it leave the previous council's name.
Yes,
So that my name.
Orders are not uploaded, therefore it is not being done.
Lord,
Whoever
item 24
appointed is amicus curiae, then will be.
Item 24 kindly taken on next Tuesday.
It will remain. I can take up any time, so that let it remain. I'll accommodate.
That refer to their matters.
No, don't.